is Thursday, July 19th, 2018, 9 a.m. to the conclusion of our agenda. We're here in Los Angeles. Could you call to order the roll call?
Good morning, Ms. Hurt.
Present.
Ms. Lisinski.
Present.
Ms. Crom is absent. Ms. Nocella.
Present.
Ms. O'Neill.
Present.
Quorum reached.
Thank you. Thank you all for coming this morning. We really value public involvement and exchange. I'd like to remind everyone that the proceedings of this board meeting are being recorded and webcasted. It's requested that anyone wishing to speak come forward as they are recognized. It is welcome but not required that speakers identify themselves. For fellow board members, I know this is a very robust and ambitious agenda. We've really tightened our belts on reducing our meetings to our essential topics. So because we do have a lot before us, please don't hesitate to let me know if you need a comfort break or you need me to slow the pace for better understanding. So this will take us, if no one has any questions, to agenda item number 1, approval of October 27th, 2017 meeting minutes. Everyone's had a copy distributed early on. Do we have any additions or corrections? Wonderful. Finding none, would someone like to make a motion?
Oh, wait a minute. I move to approve.
Thank you. Can I get a second?
Second.
Public comment? Seeing there are none?
Ms. Crom is absent. Ms. Lisinski.
Yes.
Ms. Nocella.
Yes.
Ms. O'Neill.
Yes.
Ms. Hurt.
Yes.
Motion carries.
Great. Minutes approved. We'll move on to agenda item 2. It's a report of the executive officer.
So jumping right in, on page 13, we have the numbers from fiscal month 11. So it's a couple of months behind, but this is the most current numbers that we have. And as you can see, as of that time, we're showing a surplus of 3.6% of our budget. I'm happy to answer any questions on specific line items if anyone has anything.
Any questions? Okay.
14 is the overall fund condition. 15 is the overall transcript reimbursement fund. There has not been a transfer to the TRF this year. Paula will tell us, Paula and or Melissa, could you tell us more about the TRF, where we are with that?
Okay, so as most people are aware, we've been unable to transfer funds to the TRF since the board's overall budget has fallen below 6 months in reserve. So on April 10th, we returned all applications that were received after July 6th, 2017, and we have not been able to process anything since then. A total of 299 pro bono applications were returned. We were able to approve over 96,000 in invoices in the fiscal year 2017-18 before the cutoff, and that covered 53 invoices. Does anybody have any questions about the main pro bono fund before I turn it over to Melissa?
Okay. As far as apps that were returned for 2018, we returned 188. We were only able to fund just under 2,000 for the pro per, and the amount that we've dispersed so far is only 544, so it's really low. We were able to approve much more than that last year. Just to give you an example, we had 227 applications that we received last year, approved 188, and we had just over 47,000 in funds that we approved for 2017. So being just under 2,000 for 2018 is really, really low.
Have you received any calls on the returned applications or any response from the public?
Just people asking when we're going to have the funding and explaining to them why it's been shut down and that we're working as diligently as possible to get it up and running again.
As I kind of stated earlier, I think we've all done what we can to trim down our budget. We've cut a number of meetings, we're pursuing online testing, and we've right-sized our fees, hopefully. So thank you for that important information. Are there any comments or questions from the board? Okay. Thank you.
If no one has any questions budget related, I would move to the exams. As usual, we have the most current and the historical pass rates for the dictation exam, for the English exam, and for the professional practice exam. So you can take a look at what our numbers are. I would caution you when you're looking at the numbers that we are dealing with a very small pool, and so even one pass changes the percentage by a lot, or one fail changes it by a lot. So take them as with any statistics, take it with an overall point of view. On the good news side, we have received information that South Coast Court Reporting has received their accreditation, so they are up and running, continuing to be up and running, and we're really happy because on the flip side of that, we did lose another school. Bryan is now no longer programmed, so we are down to Humphreys and South Coast as our private schools, and we still have 7 public schools, so it's very slim times in the school industry.
Are there any questions about the numbers? I have a quick question. On the July 2017 test, what a large increase or jump from 67 July 2017.
Which test? The dictation test?
Yes,
Okay.
with the increase of 67 passing with the numbers that we had prior. Can you explain or any thoughts on?
I have no ability to predict why someone, I mean, the board makes sure that we do everything we can to offer a test that is consistent at, as far as the density, the syllabic density between 1.3 and 1.5 at 200 words a minute for 15 minutes.
Mm-hmm.
That never changes. So why some people can pass it and some people can't, and why lots of people pass one and don't pass another, no idea.
Gotcha. Okay. Sometimes I wonder, schools closing or people coming out or exiting too early, maybe a part of the numbers that we saw in 2016, 2017. I didn't hear any questions from the rest of the board, so.
I would just say that we have 118 signed up for tomorrow's test. We had a couple of cancellations. We're down to 116. 11 of them, I believe, are first timers.
Okay.
We are working on the contract for the September exam. We can't announce the date for sure because the contract has not been completely signed, but it's close. So soon we will have the date, the specific date for the Sacramento test.
I'm sorry, did you say September?
No, the following, it will be in November. We're working on November dates. No questions? Okay. Enforcement activities. We have the page 22 and 23 are the enforcement statistics. There's nothing really remarkable. If anyone has any questions, we're not seeing trends as far as types of complaints or anything like that. Nothing new. I guess I already did the school update with the exams, so that's slightly out of order. On the Breeze and the modernization, business modernization, so what the Department of Consumer Affairs, Solid, one of the sister agencies that we have, are helping the boards that were in Release 3 map out their business practices. And so it's a case of coming in and meeting with staff and going through every activity on their desk in excruciating detail, as staff here can let you know. So we have a little pocket of time and they had a little pocket of time, so we are well into that business mapping process. Once that's completed with all of the different staff, then that will allow us to go to the Department of Consumer Affairs and say, you know, this is what we do, these are our business processes, does it fit within Breeze, how much would that cost? We can also take that to outside vendors and say, this is what we have, can can you build us a database that will interact with DCA database? It gives us options. So we're hoping to have that by the end of the year so we can move forward on that. Does anybody have any questions on that? That's like a really high-level overview of it. You also have in your packet the spring newsletter. It's scary to me that we'll be starting to work on the fall one soon. So if anybody has ideas or would like to contribute, please let us know. And that completes my report for you.
Are there any public comments on the report of the executive officer? Okay. We will then move on to agenda item 3, which is a fee increase regulation. This is a continuation from the last meeting. There are no new facts. However, we do need to approve the final statement of reasons, and I can draw everyone's focus to comment number 1 on page 77 of the board packet. It's the response to comment number 1 needs to be discussed, and we need to give Yvonne direction on the board's policy take. I'm also open for people talking about this agenda item outside of that specific area. Are there any questions or points of order?
Not questions, not points of order.
Okay. Any
But
comments?
maybe somebody else does.
Any comments?
Are we talking about the comment number one or just overall?
I'm giving that
Okay,
option
I
to
wasn't
you
sure.
both. I was trying to narrow us down to that being something we definitely need to decide upon.
Yeah, that's what I'm
But
thinking.
if you have a general comment about this fee increase, this is the time to talk about it.
No, I don't.
Okay. And then as it relates then, if I now take myself to page 77, that comment, as you see, we need to determine whether we're going to reject or accept. Comment number 1, can I get someone to begin that discussion? Their thoughts? Tony?
Yeah, please. I will. After I read the comment about, and it's somebody that has a CSR license from California, works in another state, maintains the California CSR license, even though she doesn't work here, and I can't remember how long she's not been here. And she's requesting that there be a status for to either have her license frozen or put on hold just in case she comes back to California. I'm leaning toward rejecting that comment because what the situation is that for somebody that does not renew their license, they go into delinquency. If within 3 years they decide, I need to have an active license, they can get the active license just by paying 1 year's worth of the licensing fee that we pay every year. So what that technically means is somebody can go delinquent, come up to somewhere in the 3rd year, pay the 1 year fee, and have their active license back. And I think that to me would be the same thing as saying that you get a reduced rate.
I just would like to point out that there is a late fee of 50%.
Oh.
So if a person renews every 3 years, they pay about half of what someone would pay every year in 3 years. So if the current fee is $125, if they renew late, it's $187.50 versus $375 over 3 years.
And the other thing is that I don't think the board staff has any way of tracking down if what somebody is saying is true or not. In other words, a reporter can say, hey, I'm not working in California, I'd like to have this reduction. We just don't have the capability to confirm that. And so in the relative scheme of things, even with a fee increase, I think our license fees are pretty reasonable. And I would recommend rejecting that comment.
Okay. Board member Nochon?
I'm in line with Ms. O'Neill. I think it overcomplicates it, and you either license or you're not, you're paying or you're not, and I think it adds additional confusion that's unnecessary and unwarranted. So I fully support rejecting the comment.
I do as well.
Okay, excellent. I will follow up to say the same. Whether the license is frozen or active, I think the cost to the staff in the process is still the same. And as it was aptly pointed out by Board Member O'Neill, they still have to follow and track that. And there is process and time and staff to do that. I think right now we're not at the place to take on this reduce fee suggestion or license frozen suggestion. And so I will also say that we should reject that. Let's now find if there are any public comments on this comment. Okay. No public comments. Do we need to make a motion on our thoughts to this? And if so, would a board member like to make a motion? I
Sorry,
did not.
I didn't hear what you said.
I said that I essentially asked our staff attorney if we need to make a motion on this, and I got a non-yes.
Okay.
And so,
I'm seeing some confusion. Would you like an explanation?
May we have one motion on this entire agenda item?
You may, it will get very cumbersome. Because the first thing they have to do is, there's proposed language already written. There have been comments made. We don't have proposed language for them to vote on. So the first step would normally be for there to be an agreement with regard to, clearly there's consensus on not adopting this comment, but we have to explain why. And so we need some consensus on that. And that would be the first motion. And the second motion would then be to adopt the FSR and authorize the executive officer to move forward with the rulemaking package.
So the motion has to include the reason why?
The law requires for rulemaking, the law requires that anytime that there are negative comments and they're not accepted by the board must justify their rejection of the comments.
So if I could summarize from the notes that I took, that we would be rejecting comment number 1 because there is a de facto decrease by virtue of having a delinquent license. The costs remain the same to staff, and the fee is for working in California, which you could do at any time. You can activate and bring it up to speed and go. And for all of and there's also it becomes complicated and causes confusion to the consumer if there are multi-levels on there. So those would be the reasons that I would propose to put in for the reason of the rejection.
So therefore, can I adopt what Yvonne just said? and make a motion that the board reject comment number 1 without having to repeat what Yvonne just said?
Yes.
Thank you. Perfect.
I second.
okay, do we have any public comments on that motion? No. Okay. And a roll call.
Ms. Crom is absent. Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Okay, so then that takes us to the second half of this agenda item, which is approving the final statement of reasons, the draft, with the hearing date of July 2nd, 2018. Can I get a motion to adopt the final statement of reasons with the comment rejection?
So moved.
Okay, is there a second?
Second.
Public comment? All right, let's call to vote.
Ms. Crom is absent. Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Okay. Thank you very much, everyone. This takes us to agenda item number 4. It is sunset review. The staff recommends the board appoint a task force to work with the staff in preparing the sunset review report. This is really important and a critical committee to be on. Last sunset review, I believe that was Board Member O'Neill and myself. It is time and labor intensive, but very rewarding. Was that convincing for you guys?
Well, first we have to make the motion to accept a task force, right? And then,
Actually,
no.
maybe it would be first good to find out if there's any question about the
Got it.
sunset review.
Okay.
To see if people are interested.
Well, we certainly would have some topics. Maybe we need to mention topics, and one would be shortage of court reporters.
That's one of many topics. I think the court reporting is evolving in many different ways, and what that technology looks like and how it is evolving is important and will need to be discussed. So again, a very important committee talking about very important things. And I think it would be beneficial to get another mix of board members too, just so that you can also get a bigger picture and understanding of what's happening at the court reporting level. I know I learned a lot. There's quite a bit of individual growth in that respect. So, are there any comments that you would like to make about the sunset review?
I would just point out that the report is due the 1st of December, so as soon as we get back to the office, we'll be jumping in on, there are quite a few tables of data that are connected with the report, so staff will compile that type of data, but then we will work with the task force members, and assuming that's the pleasure of the board to establish that, we'll be working with them to work on what I call the meat of the report, which is how we've dealt with past issues and any new issues that are coming forward. We would work with the subcommittee on that, the task force on that, and then with the end goal in mind of bringing a draft report back to the full board in September.
Okay. So it sounds like a quick turnaround.
Very quick turnaround. So we need people that have time in the short term. It'll be a short-term commitment between basically now and the meeting in September. I want to say it's the 16th.
Okay.
It's the same day as strategic plan.
Okay, great. So we have a basic outline. Are there any takers?
I'll be on the task force.
Excellent. Thank you.
I'm not going to be the task force.
I will do it because of my proximity to Sacramento,
Yes. Thank you.
but I am counting on somebody else with a lot more expertise than I have.
So I see that the task force is Board Member Lozinski and Board Member O'Neill.
Oh, I think she's the chair, though.
Already started delegating.
Yeah.
Thank you all for putting your hand up and doing this really important job. So could we get a motion?
Do we need one? Because doesn't that get appointed at the pleasure of the chair?
Yes, it does.
Oh, lovely. Just when I wanted to do another motion. Okay. So appointment of the task force. Is this sufficient? All right. Are there any public comments?
And I would just throw it to the full board and the public as well, if anybody has any issues that they would like the board to address, to be sure and get them to staff, and then we'll pass it on to the subcommittee, or if anyone knows Ms. O'Neill or Ms. Lisinski personally, they can contact them directly. But we'll get any concerns or issues that you would like us to address in sunset review into the committee.
Thank you for that. Okay, let's now move on to agenda item number 5, which is legislation. Agenda item 5A is the non-licensee-owned firm subcommittee report. That would be a task force of myself and board member Nocella. I want to thank, obviously, Senator Hill, Assemblymember Colra, Assemblymember Kevin Mullen for all the work that they've done in helping us with this process. The quick report out is that we've gone through the Assembly. It's now before the Senate. We are in close discussions with the Governor's office about best steps forward. I think we'll be moving on to the Appropriations Committee.
It's scheduled for hearing on August 6th.
Thank you. So this agenda item is moving forward. Do you have anything to add, Board Member Mitchell?
No, I think we'll have a clearer picture at our next board meeting about the status of where we're at.
Yes, I agree. Are
Can
there
I?
any?
No, I just want to thank you all for your hard work. It's a lot of
You're
hard work.
welcome. You're welcome.
Thank-
This has been, it's important, equal justice and fair justice, and that's, I think, our mission on this, and consumer protection, most importantly. So I'm very happy to put time forward, driving to Sacramento and speaking to who I need to on the topic. So, are there any public comments on agenda item 5A? Welcome. Oh, no?
5A or
Maybe. This is the non-licensee owned firm. No? Okay. I'll get you the next time, huh? All right. Seeing there are no public comments, I will then move on to agenda item 5B, which are our briefing on current legislation related to court reporting industry. And the Court Reporters Board, there are some possible actions that we can take and discussion warranted. But I'll turn it over to our executive officer to talk more about these legislation.
So pages 84 through 86 are a list of all of the different bills that staff is following. What I've done is taken the liberty of starring some things that are of particular impact to the board and how we do business, or to court reporting as an industry and how they do business. And so it would be appropriate for the board. Obviously, we can talk about any of these that are here if you have a particular question or interest in one, but the ones that have the stars that relate particularly to the board or to the industry, I'm asking for the board to let me know if they would like to support the bill, oppose the bill, or just have me continue to watch it. The first one that really has any import is AB 2138. And the ones that I deemed more pertinent have been included, the entire text of the bill have been included. So I have talked with the board members. I know that you guys have read through that in more detail. So the synopsis that I give is very general, but basically the authors of this bill, with the best intent, are trying to reduce the barriers to licensure for people who have convictions. And so they have written or suggested in this law that there are specific parameters that a board, all boards, all bureaus would be allowed to consider. And so rather than each individual board looking at each individual licensee and taking into account things like how long ago the conviction was, what the conviction was, how much does it relate to a particular industry. It's just a blanket approach of, after so many years, you can't go back and look at anything. It's just a more cookie cutter approach on trying to make it fair and even for the people with convictions coming into the licensing fields.
Okay.
I would like to make sure that the board understands some of the complexities of the statute, because this would be a fundamental shift in how your licensing program would operate. In addition to there being a flat statutory ban based upon a conviction that's older than 7 years, the statute, the proposed legislation, would prohibit you from using the underlying offense for which the conviction was suffered. This is a blanket prohibition, which means that if they were convicted in another state of, for example, embezzlement or fraud while using their professional license, you would not be allowed to deny them a license because they were convicted more than 7 years ago. A similarly situated individual who did not suffer a conviction but who suffered licensing discipline in another jurisdiction for similar acts would be subject to a license denial.
Interesting.
So you have two equal people, one gets convicted and one doesn't get convicted, they commit exactly the same act under their license. And the person who was convicted, if the conviction was more than 7 years ago, not only can you not use the conviction, you cannot use the act that led to the conviction.
So are there any comments from board members on this item?
I don't like it.
Yeah, and I may be splitting hairs here, but with the word conviction, if they came to a plea bargain versus being convicted.
So a plea bargain resulting in a
An admission
determination,
of guilt.
whether it's a guilty plea or plea of no contest, they would be deemed under the criminal justice system to have suffered a conviction.
Okay.
So I hear board member Lozinski say she doesn't like it. What about the other board members?
I feel that with all the boards California has, every board and the profession that the board oversees has its own nuances. And I think this would take or limit our ability to carry out our mission, which is the protection of the consumer. And so therefore,
There is definitely that concern. The
Yeah.
other concern that we have, those of us analyzing the bill have, are the arbitrariness of saying 7 years is a magic number, because that means that somebody who was convicted 6.5 years ago could be denied, but somebody who was convicted 7 years and 1 day ago could not, without an analysis of whether or not the severity of the situation, the facts in nature, and so there's some concern about whether or not wouldn't be deemed by a court later on to be arbitrary and capricious. So we are concerned about potential costly future litigation over this issue, which would remove a substantial portion of the board's discretion.
yes, and I can also see too where a prior conviction would have a great implication in whether somebody receives a license from one particular board and maybe another board, it wouldn't be such a big deal. Yes, I just really think that the consumers of California would not be well served by this legislation going through.
I agree wholeheartedly with Ms. O'Neill. Nonviolent offenses, there's crimes of fraud and moral turpitude that I'm concerned about protecting consumers of this profession, and I don't support this bill.
Okay. So I'll echo everyone's comments. I agree that it is a fundamental shift, and I believe our profession is one where qualifications and the function of those duties are important and should be upheld. And some crimes do not lend to proper qualifications, and it could really change the face of what we're doing. My suggestion would be a letter of caution. Do folks think that that's something they would like the board to send, or is it a complete denial that I'm hearing?
Typically, you write to oppose or you write to support.
Right, I thought that our three options were,
You can be neutral, you can oppose, or you can support.
right, but we're not neutral.
It does not sound that we're neutral. It does sound that we are opposed. And would we like to send a letter?
That was
explaining-
your question.
Yes. Does that need a motion?
Yes.
Okay, I'll make the motion that the chair send a letter to the appropriate people, and that the board, the court reporters board, opposes this bill.
AB 2138.
Correct. Sorry.
I'll second that.
Are there any public comments on this item? Okay, seeing that there are none, can we call to vote?
Before you call the vote, can I ask for clarification? Your motion, would you intend that to include, should the matter bill pass both houses and proceed to the governor's office, would it include the chairwoman, sending an additional communication to the governor's office?
Yes. Thank you.
Just don't want you to
We'll
have
cover all our
Yes.
bases.
I just don't want you to have to have a special
Yes.
meeting.
I like to be
appreciate that.
proactive.
Thank you.
Oh, you don't want that special voting.
Okay.
So with that edit, do you accept that?
I accept the amendment.
Okay, and then we, second?
Second.
All right, public comment? All right, moving forward, can we do the call to vote?
Ms. Crom is absent. Ms. Lisinski,
Yes.
Ms. Nochella,
Yes.
Ms. O'Neill,
Yes.
Ms. Hurt.
Yes.
Motion carries.
The next one that I would ask the board to consider is AB 2354. I don't know if the sponsor would like to give us more information on that one.
Would you like to come forward?
Just gonna give a big comment. Right now, the legislature's on their summer break and they're off having fun and can't even contact anyone. It's really frustrating because I want to do a bunch of work. But right now, it has passed through. It's in the Senate. I believe it's in the Appropriations Committee. And so if the legislature votes no on it, then they're going to look really awful because everybody cares about children and domestic violence. So I'm hopeful it's going to pass.
So right now, just for the benefit of the board, many different courts in California have elected not to put court reporters in family law courtrooms. And so this particular bill is asking the certain types of family law matters, it would be mandated that the county would provide a court reporter. So rather than the litigant coming forward and having to fund a court reporter from their own pocket or not having a record, in these particular cases that are outlined in the bill, the county would be mandated to provide that court reporter.
I have a question. Did I see? No. I have a question. With this discussion of labor shortage and being mandated to have a court reporter provided, what happens in those cases when we can't find someone? Does that case get moved forward, pushed down the schedule? How does it work?
Every county is doing something different. Our position is they just need to open up the funding and restore staffing now that the courts are getting more money. They are getting more money, and that's just, we had a meeting last week with the Judicial Council and told them as such.
Okay. So it's more of a funding issue, not
Allocation.
It's the way they're spending
They're
the funds, right.
okay. Are
And-
there any? No, please continue.
I was going to say they've used the fund, the courts are using the funds for other employees, so now they need to use them to restore court reporting staffing.
Okay. And is CCRA the sponsor?
Yes.
Okay.
CCRA is the sponsor, and I'm Carolyn Dasher, the president of CCRA. Thanks.
Are there any other questions? No? Okay. So, again, this is another one of those, do we want to oppose, do we want to support, do we want to stay neutral and watch what happens with this legislation?
I move that we support.
Okay, I second. And I see multiple nods. Okay, second. Any public comment on the board supporting this legislation?
Ms. Lisinski, if I may offer a friendly amendment to your motion to support it, but also empower our chair to send the letters that we have talked about.
Perfect. Yes.
Would you accept the
I
amendment?
accept your.
Thank you. Okay.
I missed the second, I'm sorry.
So the amendment, who the second is? It's O'Neill. Okay. Call the vote.
Ms. Crom is absent. Ms. Lisinski,
Yes.
Ms. Nochella,
Yes.
Ms. O'Neill,
Yes.
Ms. Hurt.
Yes.
Motion carries.
Okay. That takes us to, let's see, AB 2483. It has 3 stars next to it.
It's dead, sorry.
Dead. Moving on along. AB 2531.
Yes. This one's also sponsored by CCRA, so I'm not sure if Carolyn would like to address that again. In a nutshell, it is a version of.
Sure. So this is another version. We tried to pass it through the following legislative year. And basically, we're trying to authorize the board to certify our cart providers so that they have some kind of licensing we're going to see more and more cart providers and flooding the workforce, we're hoping. And I'm just hoping the board would support this. It's also in the Senate appropriations, so it has passed all the way through. Gallagher is probably one of our only Republican supporters for court reporting because his brother is hard of hearing or deaf. And so he actually votes for our other bills as well. He's the only one.
Has it been determined how much this will cost the board?
I'm not sure.
So I know from working with the Office of Information Systems that it's sort of a minimum flat fee for them to reprogram a system that we would be able to track, because there is, while we wouldn't be issuing a license for them, there is a requirement in the bill right now for us to report to the legislature on numbers. And so we would have to find some way of tracking them. To add that to our database is like a flat fee of $45,000.
And, you know, that's my only hesitation. I am all for the concept. However, the board can't absorb this kind of cost. I think there needs to be an amendment that adds some kind of, the board have the ability for, I don't know whether what the language is, but in other words, like we pay a licensing fee, there'd be some kind of fee, and then even then, I would really like to have this, I don't know what the term would be, like a neutral in the sense of, okay, if there's going to be additional work, there's got to be the money there, because as efficient as our board is and our staff, and our staff is extremely efficient, when you start talking about volume, you know, you can only do so much with what you have. So that's my only concern about this.
Can I respond? So currently CCRA does have a certification program for cart captioners, and we provide the test 2 to 3 times per year. So right now we already are certifying cart captioners, and we could always discuss the requirement of the board to send how many licensees. We can always discuss that.
Yeah, and I don't, you know, between CCRA, between NCRA, I have no issue with the process of getting that requirement. I'm just really concerned about the practical matter of having the board having the funding to take on those extra duties, because I mean we are real razor thin on what we do and the money. If that could be worked out, I think this would be great.
If we took the reporting requirements out, then I think that the last piece left on the board would be accomplished through regulation. So it would just be the staff time committed to get this through the regulatory process.
Yes, and I would think that, you know, in your discussions about whether CCRA wants to do that or not, if we take out the mandated reporting that's in here, as you see with everything else, we always get an overview at meetings of what's going on and who's doing what, and just like with the test. And so rather, it might not be a formal reporting, but you would have that information.
Right, and perhaps CCRA, we can report to the board who passes our certification, and then perhaps you could reach out to NCRA and then ask them the same thing to send you literature on that.
Well,
And
it's
then
like
you
for
would know.
NCRA, I know they give you a certificate. So we would, I don't think we'd even, as long as they can provide that certificate, you know, that, it's more the reporting part that's going to be onerous.
Well, we can discuss that.
Okay.
We're open to discussion.
Yes, so the synopsis in the language suggests that the board would become the standard-setting body. If the board becomes a standard-setting body, that will require meetings. So even though and then of course the regulations. So even though it may be significantly less than if we were having to track, there will be some potentially substantial cost depending on how many meetings are necessary in order to come to consensus as to what the standards to be adopted are.
Thank you. So I think this would be an evolution in what we're doing by adding this, and an important one. But for me, this mandated reporting, we are the standard setting body, and there are no fees associated to get that work done is where this falls short for us. So until we see that, my position would be not to take a stance on this, to watch legislation, to see how it evolves. And again, this is something too, I believe we can take up in sunset review, and we need to watch this a little bit more because of the costs. Are there any other comments from board members?
I would say that the subject matter of what you're trying to accomplish is incredibly just and absolutely needed. So I think to your point, Ms. Hurt, we have to figure out a way for us to not absorb those costs, but figure out a way where we can work that out and pay for it. And so perhaps an opportunity, is it fair to ask that we empower our executive director to continue to work with CCRA to see if there's some type of, we can bridge the gap and figure out some potential amendments on the legislation that ultimately maybe we could support down the road.
So is this something that you do now when it comes to sponsors of legislation? Do you continually talk with them about how it's evolving and get more facts that you can then report out to the board at the next board meeting?
If they contact me, I don't usually
Reach out to them?
them.
Okay. So then I would urge, I hear or see a nod, shake, and a thumbs up, to please stay in close contact with us with how this bill evolves and what really is mandated in the end, and how you can help with fees or funds to make sure that we can do the job well done. Okay? So I guess we don't need a motion to that effect. It's just a comment, or do we? I'm looking at our
Are you
attorney.
going to take a position on the bill?
It sounds as if we're not going to. It sounds like we're going to watch it and see where we are.
Would you like to advise the author's office that we are in support of the concept, and if we can work on the fiscal details, we would be supportive, or do you want to not commit that much?
I mean, this is a board decision. Myself, as one of many board members, I think that we should just wait and watch. I think we have a lot already on our plate, and I think the extra step of sending a letter and communicating in that respect is more that needs to be done at this time, especially where it is sitting right now. Are there any other thoughts different, or?
No, I agree.
You agree? Okay.
I just had a comment. That's exactly what I was gonna say. If perhaps you could contact the author's office and just say you're in support, but we're discussing with CCRA, because I think that would hold weight. And I think it really is important, the more our career moves forward, to keep our steno reporters, our card captioners certified and moving forward into some kind of licensing. And I think that's more important. So, thank you.
Thank you for your public comment.
Well, do we need something to say that we are going to do that?
Well, that was my initial request. We wanted to put out a motion where we asked our executive officer to communicate with the sponsors and the author of the bill. And my position is, I don't think we need to do that step right now, based upon where it is. But that's just my opinion. Are there others who would like to call the author's office and let them know that we support the concept, but we're not prepared to support the bill? To me, I think
That's a little awkward.
it is, and that's why I think we should watch a little bit more to see how the legislation pans.
Yeah, I agree.
As an aside, if I may offer a somewhat relevant comment to this topic, I was in Sacramento a couple months ago, and I was enjoying a lovely floor session, and I was sitting next to, when you're in the gallery, I was sitting next to a lovely group of folks, and one person who was watching was deaf, and I quickly noticed that there was no ability for them to understand the proceedings, and so while you're talking to Assemblymember Gallagher, perhaps explore that opportunity of providing card captioning in the assembly floor.
So I've been asked to address a potential alternative. About 10 years ago, an issue came up with regard to the massage industry, massage therapy industry. They have, after many legislative sessions and a substantial amount of participation by the government and agencies like the Department of Consumer Affairs, as well as the associations related to the massage therapy industry, it was determined by the legislature that the best method would be to allow one of the nonprofit associations that were championing the licensing venue to become the standards setting body. Because of the nature of massage therapy, the certification or licensure through that body was deemed to be voluntary. Some jurisdictions, some counties, some cities require you, in order to register as a massage therapist in their jurisdiction, to be certified by that standard setting body. It may be more expedient for the industry itself to identify which, because of the cost involved, to, rather than going the process of having the board be the standard setting authority, to have the association, if there's concurrence in the industry, as identified as the standard setting body, and have certification be determined to either be mandatory or voluntary with regard to a licensure in that manner. There is a strong push in the state of California right now to reducing barriers to entry of the professions. There is not a substantial, at least what we're seeing, there's not a substantial motivation to increase the burden on industry for obtaining a license, and it may work out to everybody's advantage if something alternative to having the board's authority expanded. It's just one alternative, and that you should be aware of, that there's another model out there that exists.
Okay, thank you. Any other thoughts or comments on this one? And it appears as if we're just going to stay neutral and watch this legislation. Okay, maybe 2664, please.
I don't know if the sponsor of this one is here or not. Carolyn, are you co-sponsor? Or just in support?
Almost. So
You know a lot, huh?
I'm Carolyn Dasher with California Court Reporter Association. We are in negotiations and discussions with the two co-sponsors currently, and SEIU has now become involved, so we're kind of acting as an intermediary to help with between the two. So
Who
try.
are the two co-sponsors?
It is the consumer attorneys, Larry Doyle is their lobbyist, and then DRA with Ed Howard. And we had a conference call with everybody about a week and a half ago with CCRA and SEIU, and then we've been throwing back and forth language and talking to Holden's office.
So basically, this bill is trying to solve a problem where in civil courts that do not provide court reporters, and so the litigants are bringing in their own court reporters. If the lawyers are not able to come to an agreement and stipulate on having a court reporter, apparently one side can say, no, I don't want to stipulate, and then the other side won't. And so this is trying to solve that problem by allowing one side unilaterally to bring a court reporter in if there's no stipulation. That's
And if I may,
oversimplified.
it's a little more complex than that after we did a bunch of research. So Santa Clara in particular has a local policy because none of these are rules of courts. Different counties are doing different things. So it's their own local policy, and there's two things where it fails. One, it requires them to stipulate 5 days in advance for a court reporter, and if they don't do that, then the judge can deny them a reporter. So those two prongs. So it's actually more, we're finding as we research, a more local situation that's happening because all the other counties, it is working properly, so that's why we're trying to work on it.
Thank you. Are there any other questions? No? And so do we want to support, oppose, stay neutral? A shrug?
think for myself, I support the idea that there are options to have someone provided if the parties cannot agree. So I'm supportive of it, but
I am too. I've always said that it's pretty amazing to me that you have 52 counties in the state. We all work under the same statutes and the same rules of court, and yet every of the 52 counties do it differently. And I think this would bring a standard, that all the counties have to follow, rather than, having their own local rules and in some areas, attorneys are practicing in this county, and this county, and this county, and trying to figure out what the rules are, I don't think helps the consumer. So I'm in support of this legislation.
Board Member Lisinski, or?
Well, I was just more concerned that that they're saying they're still working on it. So what we have is not in its final draft. So I'm supportive of the concept, but they're still working on it. So I don't know what that final wording is going to be. I don't know how substantively changed it will be.
So as I understand, and Dr. can help us with this, we always have the opportunity to withdraw our support if the legislation changes dramatically or takes a turn for something that we don't believe in. I find that our executive officer is always closely watching and is informed by others when legislation begins to change or alter in a way that is not what the board intended to support. So in that respect, I think we can still support it and watch as well. Board Member Nutella.
I'm fully supportive of it because sometimes it's just great to support things that are the right thing to do. And this is the right thing to do.
Okay. So with that support, are we sending a letter of support to, it seems there are several people that are involved sponsoring and the author?
Just the author.
Just the author? You don't want to send out 5 letters?
I'm just gonna deal with the author. It's the process. And obviously, if it doesn't get amended significantly, it would go to the governor as well.
I would make that motion.
Thank you. Is there a second?
Second.
Okay, can I have public comments on this item? Okay. Call to vote, please.
Ms. Crom is absent. Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
And the last one that I have starred for the board's attention is AB 2757. As I think the board is well aware, the transcript rates for transcripts prepared from court proceedings are established by the government code. And that government code has been in place, Tony, correct me if I'm wrong, 1991 is the last time that was increased. The sponsor of the bill is here.
28 years.
Yes. I went to court in 1990 because I thought, oh, this is great. I'm getting a raise right away. And then that's been it.
Yeah, so I'm Carolyn Dasher, President, California Court Reporter Association. This there's been multiple bills that have been put forth for at least the past 10 to 15 years. So this is once again, the last time I was in the legislature, got all the way to the governor and he vetoed the bill. And then he said it should go in the budget process. We did that last year and it didn't get put in because there's so many things that go in the budget process. So here we are again, trying to get it in the budget process as well. But Assemblymember Reyes is really a champion for women and women dominating career issues, and she's wonderful. So yes, we urge the board support. 28 years. We're trying to get reporters, we're trying to recruit reporters, and it would be really helpful if we could get this through, and having your support would be wonderful. And if you have any questions, I'm here.
Are there any board questions? All right.
this is another one of those items that we can support, oppose, or be neutral on. What do you think, Board Member Nutella? What's your position?
I'm fully supportive of us supporting it. Long time overdue, and again, right thing to do.
Okay. Board Member O'Neill?
I definitely agree about taking a stand of supporting this bill. I mean, there's times where it's a penny more, and as it's graduating, so it isn't like the consumer's going to be hit with a huge, bridge over to a higher rate. And I won't go into all the other issues with it. It is long, long overdue, and I think it's a very reasonable process that is included in the bill as far as the rates. And this profession, especially being a woman-dominated profession, deserves a raise after 27 years.
I'm 28 this year.
20. Okay.
Almost 30.
Yeah.
There you go.
Nearly 30.
Yeah.
And I would like to say that I'm supportive, and I do think that the impact on the consumer will be fairly minimal. Because that is really our primary concern is the consumer. And I think the impact to them will be minimal. And I think the benefit to the profession will be large. And in that way, the consumer is actually aided. So I'm supportive.
I agree with you, Board Member Lozinski, and I won't repeat all the comments, but I agree with those that have been said before. And so, can someone throw a motion out there?
I make a motion to support AB 2757 and empower the chair and executive director to write a letter of support to the author as well as the governor if needed.
Thank you. Is there a second?
Second.
Public comment? Yes, please.
Good morning, I'm Jennifer Escobar. Excuse me, I'm the Secretary Treasurer for California Court Reporters Association, and I'm here today representing the freelance deposition reporters as well as CCRA. And I did want to provide you with a brief comment because I am a deposition freelance reporter. I think it's important for the CRB to note that recently there was a decision that came down holding freelancers to the statutory rate in court when they provide services as a per diem or pro tem court reporter as a freelancer, and that we are obligated to charge the same transcript rate as an official currently. And this provides a hardship for many freelancers because we obviously are not provided the same benefits as a self-employed independent contractor. We don't have benefits and health insurance and that kind of thing that's provided through an employer. So I did want to make sure that the Court Reporters Board understands that when this decision came down, it did also affect the freelance deposition reporters in the way that we are not able to charge what we would normally deem an appropriate rate based on our own personal business expenses and the expenses that we incur in order to provide the service to the litigants and the attorneys in court.
Thank you. Are there any other public comments? Further discussion? Call to vote.
Ms. Crom is absent. Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurch?
Yes.
Motion carries.
Were there any other, if no one wants to talk about any of the other ones? I don't know if any of the board members had additional comments on anything I had flagged.
I don't have any additional comments. I think we can move along. And if I could right now, 5-minute comfort break for everyone, please. Thank you. You're welcome. meeting of the court reporters is back in session. We just finished up agenda item number 5, and now we will move on to agenda item number 6, the results of the reporter working speed survey.
So this comes back before the board. The board's been very concerned. We've heard a lot of input from the public on perhaps the dictation portion of the exam is being overly ambitious, too hard for the candidates. We reached out to the Office of Professional Examination Services, the sister agency with the Department of Consumer Affairs that helps us develop our written tests as well as coordinates and validates our occupational analysis. And they came up with a survey for working reporters, much like they do to start off the occupational analysis. I consider this kind of a supplement to our occupational analysis. So statistically, they sent out and got enough responses to make it statistically relevant. They asked a lot of questions from the working reporters. I have the full report, but basically they were saying, of the last 5 proceedings that you reported, how fast were they, how many years have you been reporting, what part of the state, what kind of proceeding it was. So there were a lot of factors that they took into consideration. They asked the people responding to the survey if it was like their own best guess at how fast it was. Some of the CAT softwares, the court reporting software, has like a little meter that tells how fast people are speaking, well, how fast you're writing, which should be very close to how fast people are speaking. And so it was a very detailed survey. Long story short, I put some of the survey results in the cover sheet on page 112. So you can see about some of the full results that came back. The bottom line is they are recommending that we continue to test at 200 words per minute as entry level, as a good entry level into the profession.
Okay, are there any comments from the board?
I agree with the, just from my own on-the-job observation, I agree with the conclusion. Because we're already doing, or the test is being administered at 200 words a minute, we don't need a motion or anything to adopt. Okay.
No.
It's
No,
just,
it's here for discussion, so if the board did want to change
Okay.
or did want to take action, you could.
okay.
If no one wants to take action, then it's just informational.
I think it was important. I think there were some theories about why we were talking about this that were not based in fact. And for us, it was good to have this agenda item so we could talk a little bit about why we brought this up. And it was because there were complaints. And so we felt the need to take a thorough review. And that's what's happened. I had a fun fact that I looked up when I was trying to base my decision on what other folks were doing. And I noticed that the Guinness World Record holder in Houston, Texas, he's the fastest court reporter in the world, accordingly.
Mark Kissenberry.
That's right. At 300.
We know him.
Do you?
Yeah.
We need to invite him. At 360 words per minute.
He's amazing.
So 200 is really far from there. Okay. It's really far from there.
I do 360 every so many seconds.
What's your accuracy? That's the next thing, right? Wow. So we just wanted to let folks know that we really did take those complaints to heart, and we wanted to make sure that we were producing folks who could do the job. And so that's what this review is, and we found that that's the 200 was accurate of what's needed to do the job.
That does remind me that I got equally angry comments from the public demanding to know why the board was trying to make the test faster, and equally angry saying, why are you trying to make the test slower? Like, we're not trying to make the test anything, we're just trying to find out what's the right speed for entry level.
Yeah, and I say this all the time. I'm also a council member in a city, and oftentimes people use things like Nextdoor as their source of information. Mm-hmm. And I'm here to tell you that your best source of information on anything you hear happening is the board. To give us a call and find out what it is that you're hearing out there.
because I'm not going to use I'm going to say it, the false news thing. Don't go for that. Just go straight to the essence, and it's the board, and we'll be glad. We have nothing to hide. We want to see reporters out there. That's what we want to see.
So we can just move along, right?
Yeah, I just said my piece, and unless you have something else to add, we can move on.
No, I certainly don't want us going for less, so.
No. Okay, so you're fine with 200. It sounds like
Yeah.
Board Member O'Neill is, and I see a nod from Board Member Nocella. So I would like to open this up for public comments, if there are any on this agenda item. Oh, sure, please come forward. You can come up to the mic so we can all hear you, because it's
Yes.
better if you do so, because it is webcasted. Everybody wants to hear what you have to say. You're welcome to give your name if you'd like, and you
Good
don't
morning.
have to.
I'm Lori Daw from Argonaut Court Reporting School. I just was curious who the complaints were from regarding the test.
Sure.
So if you go back to any of our board minutes, it will identify the speakers, but we've had a number of members of candidates who were not successful with the test, members of their family.
Not the consumer, not attorneys, not judges. They were not
No,
complaining
they were
about the
candidates
speed.
or candidates' families.
Thank you.
I think one of maybe those family members was an attorney.
Yes. Yeah, the father.
Yeah,
Right.
the father was an attorney. And actually, that brings me to a good question, and I think we may have already gotten it answered. Were there any schools that contacted you to say that they can't teach to these numbers? And
No.
the answer is no, and that's an important one. So, thank you for. So another question I think is really important were there any schools that came forward to say we can't teach to the 200 words per minute? And there were none. There were no, that was a question, yeah. So I think that's important and telling, that the schools believe that the students can do it, and we have the information to base it that it should be required because that's what's asked in the industry. So I have looked at the agenda. We have quite a few items, and I know we have some folks who have hard stops. It's my suggestion to change things a little bit out of order. I would like to take up agenda item number 6, our closed session, right? Oh, thank you very much. Agenda item 16. Our closed session right now, and we will start agenda item 7 at 1 o'clock, right after lunch.
Okay.
Okay.
Are there any thoughts on that?
No, but they're.
No?
No, I think that.
Okay.
Extended.
Okay, so for the folks out in the audience here, we are going to take on our closed session item. And we will return back to agenda item number 7, which is the reporter labor supply at 1 o'clock. Reporters Board is back in session. It's 1:03. Our next agenda item is going to be a big one. It is agenda item 7. It's in regards to the reporter labor supply. Before us, I believe we have a presentation of the voice writers. Would you give them a proper introduction?
I'm actually going to turn it right over to Mr. Don Scott, the president of the National Verbatim Reporting Association.
Thank you, Ms. Penner. It is indeed our pleasure to sit here before you today and speak. We are voice writers. I am Don Scott, the current president of National Verbatim Reporters Association. With me today is Tori Pittman, reporter extraordinaire. I believe many of you know her. 1968, I want to take you back then. The siege of Khe Sanh, the Tet Offensive, we were embroiled in a conflict in Vietnam. For the entire year, we were seeing, we were watching on the 6 o'clock news, the 10 o'clock news, Walter Cronkite and other announcers show us photos, film clips, black and white, of the streets of Vietnam. Many of those gentlemen my age joined the armed forces. In the spring of 1969, I joined the Marine Corps. They sent me right out of boot camp to the Naval Justice School in Newport, Rhode Island. My drill instructor, for the first time, smiled at me, called me Private Scott, and said, "You're going to be a court reporter." And I thanked him. I had no idea what a court reporter was. So after basic training, I went to Newport, spent a couple of months learning to be a steno-mask court reporter. After 4 years in the Marines as a court reporter, I went to the East Coast. I went back home to Virginia, and I went with a reporting company in Washington, D.C. Our company reported the Watergate hearings at the time. That puts you in a proper time frame, I believe. Spent a couple of months learning the ropes in the Senate and House work, decided that just wasn't for me. So we set up shop in Virginia and began doing the felony and civil freelance type work with this firm. Now let's drop back to the 1940s. We had a gentleman by the name of Horace Webb, who was a pen writer, Greg Shorthand. He was a couple years into his working and sat in the courtroom one day and thought there's got to be a better way. He put his hands to his face and began mouthing or parroting what was being said in the courtroom. He said, this could work. So he went to various machinists and the like and tried to develop a mask with a microphone in it that would record his dictation. So at that point, the concept of voice writing was born. He went through several variations, of course. Into the 50s, the Naval Justice System, Naval Justice School, picked up on the steno-mask. We were embroiled in Korea at the time. The Uniform Code of Military Justice had just been revamped, the 1950 code, and it really turned our legal system and the military on its head. They needed court reporters and they needed attorneys, and they needed them fast. So the Naval Justice School at that point started teaching the steno-mask system put together by Horace Webb, for which we are eternally grateful. By the late 50s, the steno-mask was thoroughly ensconced in court reporting, and it made its way to the West Coast. I don't want to cast aspersions at this point, but the National Verbatim Association, Reporters Association, got its start right here in California. I feel we've come full circle. In 1967, California court reporters and the state of California decided they didn't want voice writers working in California. So the voice writers created their own association. They called Horace Webb up and said, "Will you help us?" And he said, "Yes, but only if it was a national association." So the following year, the California Steno-Mask Reporters Association became known as the National Steno-Mask Verbatim Reporters Association. They fought California and lost. They then went to Pennsylvania, who tried a similar move and won in Pennsylvania, so the voice writers could report in Pennsylvania. At a point in the late 70s, early 80s, it was found that steno-mask was copyrighted, a registered trademark. So the association dropped StenoMask from its name, and it became the National Verbatim Reporters Association. That also meant, what do we call ourselves? We're no longer StenoMask reporters, and the term voice writers was coined. I don't want to fast forward too quickly. I want to talk about what it is we do. We speak into a mask, as you see Tori doing here. Some would call it re-speaking. That's a term of the last couple of years that has come about because of speech recognition. Some call it parroting a speaker. But what we're doing is, from the get-go, from the 1940s, we listen to you speak, we identify who's speaking, and then we repeat what you say. Then we go home, because at that time we dictated into various recording devices. We then got on our typewriters with a dictation transcriber, and we typed out the transcript. Personally, in 1969, I started with a wax record, the gray autograph machine, and we moved on from there. Today I'm using a SpeechCat CAT system, which everyone in the room I trust is familiar with, the CAT system. We identify whether it's a question or answer. Q, what is your name? A, my name is John Q. Citizen. Then that worked really well. The concept was, I have dictated everything in the courtroom that I want to see in my transcript. So I go home, I either type it myself, or I hand it off to a transcriber, who then transcribes the transcript, the deposition, the trial. Without ever having spoken to me, that transcriber should be able to produce the transcript. Best case scenario. Well, in the 70s and 80s, a lot of the machine writers that I knew would go home and dictate onto a transcriber and send that to their typist. The very thing I had done in the courtroom. It seemed a time saver, worked well, but then as technology advances, along comes real time. We jump ahead again. We have many.
Mr. Scott, could I have you jump maybe even further ahead to what's happening closer to 2018? So we can talk more about how voice writers can be beneficial or not. That's all a personal answer we all have to come to about our labor supply shortage.
I understand. Being in your position, brevity is the word of the day.
Unfortunately, there are a lot of speakers, I think.
Well, kicking off right from where I just ended, we do the same thing that a machine writer does in the courtroom or in a deposition setting, only our input is voice rather than keystrokes. We have CAT systems that have recording programs embedded. They have transcribing programs embedded. As you see with Tori's feed here.
Not right now.
Just we were seeing it earlier. Yeah.
We have the capability of real-time output. Dragon and a couple of other speech recognition programs in the early 2000s gave us that capability. The programs have improved greatly. Today, we are able to certify our recorders at 180 words a minute with, I believe, 95% accuracy. I could be wrong on that. But those are the people with CAT systems. Not all voice writers use CAT systems. Some voice writers will use simply a dictation device, a digital recorder, a business recorder, and will plug their mask into it and then go home and either transcribe it, as I spoke of earlier, or have Dragon transcribe the audio file and then they will go in and clean it up. A great time saver, as you can imagine. We can do everything a machine writer can do. Indeed, Tori is using the Eclipse program, which many of you are familiar with, I'm sure. Again, the only difference is that cord that's attached to her laptop that is sending her voice to Eclipse. I have a mask here I was going to show you if you were interested. You will see that many of our masks have two outputs. That's because they have two microphones inside the mask. The reason for that is redundancy. We will plug one mic into the laptop and plug a second mic into a dictation device, a recorder, a handheld. We never trust computers, though they are our livelihood. Our reporters have the same certification speeds and accuracy as NCRA's certifications. They're identical. I think it is interesting to note that when our association was formed and it was decided to certify and educate court reporters, it was decided then that our certification speeds would be higher than that of NCRA. I've heard it said that that was pure arrogance. I've heard it said that we want to be able to show the world that we can do this. Of course, we were fighting the machine writer associations. We had to show them we could do it. In just the last year or two, NBRA lowered its certification standards to match those of NCRA, simply so there would be less confusion out there in the marketplace when it came to certification speeds. Everybody, we call it a CBR, you call it an RPR, it's the same recording speeds and same words per minute, the same syllables, the same syllabic content. Our tests are handled by, or we are guided by, the psychometric designs and guidelines of the country, whoever they are, but in every way identical to NCRA's testing program. We are able to, as I say, do everything in the courtroom that a machine writer can do with their CAT system program. We can read back, we can play the audio if the court wants. You can read our screens, you can send a real-time feed, we can send it out over the internet. There's just nothing we can't do that a machine writer can do. And in that end, we would like to work as officials in your court system. We would ask that you pursue a change in your legislation that would allow voice writers to apply for licensure in the state of California. We think this is important. We don't kid ourselves. We know even at that, we're fighting an uphill battle with public relations. I understand voice writers can work in this state in the freelance setting, but we're fighting attitudes and perception. Too long, people have said voice writers can't do the job. They're not real court reporters. We hear the same thing right now with electronic court reporters. We don't want to do to them what we felt was done to us. So we are sympathetic to their needs, but we do want to change the perception that voice writers are less than the equals of the machine writers. We ask your help in pursuing that change in litigation. I'll ask Tori if she has anything she wants to add about what it is we do on a daily basis to prepare a transcript.
Thank you. I'm thinking I'm close enough to the mic that people can hear me. My name is Tori Pittman, and I am a former machine writer. I have the Registered Diplomate Reporter certification, which is the highest certification in machine writing. I'm also a fellow of the Academy of Professional Reporters, which is a nominated position. You have to be nominated by your peers. I live in the state of North Carolina, which is a state that does not differentiate between the method of how you take down the record After I graduated from court reporting school as a steno reporter, I practiced for about 5 years in freelance, and I developed tendinitis in both of my arms, both of them. And because I recognized that my state allowed us to practice, I decided I was going to cross-train to learn how to be a voice writer as well. I am self-taught as a voice writer, and the one thing I can tell you, the reason I did not pass the CVR the first time is that I was terrified that people were going to hear me. And this is something that's really important that people understand, that a machine writer understands, that a voice writer must be is silent. If you go into the certification exam and the proctor stands 2 feet from you and they can hear you more than a slight sibilance, you will get a tap on your shoulder and you will be warned. If you get the second tap on your shoulder, you are not allowed to continue to take that certification examination. That is a fail. So the reason I did not pass the first time is because I was so nervous that someone would hear me. And I was so nervous that someone could hear me that I couldn't hear myself. And if you can tell, I'm kind of loud. So I had to modify, I had to modulate my voice down. And this is a skill that we have to learn as voice writers. As a steno writer, I can write and I can breathe whenever I want to. The only thing I have to worry about being heard is my machine clacking? Have I maintained my machine correctly? When I'm reporting as a voice writer, I have to change the way I speak so that I can speak into this mask so that the computer can understand me. And this software that Dawn talked about, this Dragon software, we are using it not the way it was originally meant. It's originally meant to hear your standard voice. So I have to modulate down so that the computer can understand me, but nobody else can. I managed to get my CVR the second try. I also got my certificate of merit at the same time because I only had to take the literary portion that second time. I continued to work as a freelance reporter, still doing steno because I could modulate how much time that I worked on the steno machine. As I became an official court reporter, I found that I could not write on my machine 5 days a week, 7.5 hours a day in the courtroom at the speeds that were required. I was a freelance reporter. I didn't have the brief forms in my fingers to keep up with a plea hearing. And so I ended up practicing in civil, in steno, and in criminal and voice, and it worked out really well. I was able to create user profiles to get a real-time screen. And I know the next question is, what is a user profile? Just like we have our dictionary, as we, as a steno writer, write on the machine, we have created this dictionary that translates the steno stroke into the word that we want it to be on the screen. We, as voice writers, have a lexicon, if you will, coming from Dragon that we then can add to and tweak, such that, as he was saying, our Q and our A tokens, where on your steno machine it's a bank, I will say a voice token, keek or cack, to get a Q and an A, and I have to add that to my user profile, my Dragon dictionary, if you will. Fast forward to about 2011, I stopped writing almost exclusively steno, and now I'm only doing voice because of the volume of work that I'm doing in freelance. I am very busy. We also have an issue with having enough reporters to fill jobs, and I find I am much more efficient being able to do longer jobs with voice. The breathing is an issue. As I mentioned earlier, you can breathe whenever you want to. In order to get a good translation, you have to modulate your breathing, and you can't keep talking while the mask is away from your face while you're taking the breath. I am still using the same software that I always used. I've been Eclipse right since I graduated court reporting school. I just added the voice module to it. Everything is the same, except for I can share with you if anyone has had the recurring dream that you get to the job and you left your machine at home. That actually happened to me last night. I got off the plane and started setting up my equipment, and my standard mask is this one. But after my job on Tuesday, I cleaned out my mask like I always do, and I took out my sound dampening and I left it on my desk at home. So when I tried to transcribe last night and practice using this mask, because there's extra space and there's echo in here, I couldn't. So I literally had to use this mask and create a brand new user profile. So what you saw on the screen was not my standard real-time. My real-time is much better, but this was from the recurring nightmare. Oh my gosh, I've left my equipment. This is something that I think is a really good tool for voice writer, for any court reporter, but a voice writer is doing exactly the same thing that a steno is doing. We're just doing it in a different way. So whereas a machine writer may have difficulty with longer words translating, a voice writer loves long words because it can only sound like one other word. Whereas a machine writer is really good on the small words and phrasing, a voice writer is going to be really concentrating on the small words to make sure that the words that sound the same, were and where and we're, are crisp and fixed in our dictionary. I am currently, I did practice at the NVRA convention. I competed in the real-time competition, and I scored a 97 point something or other in the real-time competition, and I did not win, but it's doable. Real-time is something that is out there. As you see, the software is available. I could use any software that any machine writer can use to provide the real-time feed, whether it's on a computer or out on the web. And I know I kind of rambled a little bit, but please ask me the questions and I'm happy to address them.
Well, thank you all for the presentation. I should let the public know why exactly you're here. Again, the agenda item is the reporter labor supply that we have. And the board's been receiving information that there is a shortage of court reporters. And so NVRA has come forward to present information about what they do, hoping that it could be considered as one of the options in alleviating possible shortage. We appreciate the demonstration. I'll now turn to my fellow board members to see if they have any questions of the voice writers. And I'll start with a hand up, which is board member.
So could you just, I thought I heard that you said that does 180 words a minute. Did I hear that correctly?
That is our real-time.
Sorry?
That is our real-time criteria. It will record just as fast as you can dictate. Our speed test that we no longer give tests at 350 words a minute. Our certificate of merit tests currently at 200 literary, 240 jury charge, and 260 words a minute Q&A. That's the merit. Our CVR is identical to NCRA's.
Right, so because I went back to our notes from today, from our working speed survey, and our license exam is at 200 words per minute. So it meets that requirement, correct?
Yes.
And I guess it falls within the speeds that were reported in this survey for mean and average reporting. So it falls within those speed parameters.
And if I could just, myself, I am certified at 300 words per minute. I am what they call a CVR CMM. So I took the certification before the changes came. So I am certified at the highest level, which was 300 words per minute Q&A for 5 minutes at 97% accuracy. Now, what I can share with y'all is that as the computer speeds, our processing speeds have gotten better and better. We all remember the 286 processors of the 80s, and now we're up to Pentium 7s or whatever, i7 quad cores. The faster the processing speed of our computers, obviously we are getting better drop-down rate because we were running 2 programs at the same time. So we're dealing with memory, we're dealing with speed. I am running Dragon, which is a memory hog, and it's taking all of the sound that I'm bringing in, trying to come up with a word, and then I'm also working with my Eclipse software. So the faster we can get words in and the faster the computers are, the faster I can get words out. It also has to do with dictation. You hear me speaking in my normal tone of voice, but the way we as court reporters can focus on getting our real-time feed out is to change the way we speak. So, for example, I might say, state your name for the record, please, Ka. Mr. Smith. Kak, my name is John Smith. Keek, okay, thanks. And so what we are doing is we are speaking in small pieces so that we automatically have a fast drop, just like you would in steno. There may only be a split second every time there is 2 or 3 words that come out. But that is a skill, that is a practice skill that we as voice writers learn because the software wasn't intended for what we are using it for. It was meant for straight dictation, and so it's going to keep a whole packet, a paragraph of words. So we have to say, nope, Dragon, send those words out at 180 words, at 200 words, at 240 words, whatever speed we're at.
Are there any other questions? Yes, I have a couple questions. So you mentioned in North Carolina, Ms. Pittman, that you practice in a state that doesn't have a differential, it doesn't differentiate between methods. Do you know, on behalf of the association, do you know what other states, how many other states practice, or Mr. Scott, in that capacity without a differential?
I'm not sure of the differential term. There are currently 38 states that voice writers practice in, as well as the District of Columbia, all federal courts, and all military or armed forces installations.
And you indicated, Ms. Pittman, that you also practice traditional methods and then voice writing methods, and you do that because you have a disability that you need relief from. Do you know of your folks who practice in voice reporting, what percentage of people have a disability? Because I think that this is an interesting concept to afford a profession to a group of people who may otherwise be disabled from traditional methods.
Thank you, Ms. Nasala. I actually do not know that number, but I know I've been approached privately by people who are running into this problem, whether it's tendonitis or carpal tunnel syndrome, tennis elbow. As you know, we sit in a certain position. And so people are tending to have problems with their arms and backs and shoulders, and they've approached me about this. This is not something that I've done any research on, but I can tell you I broke my arm last May. I broke it and I had surgery, and I was able to, 1 week after surgery, go back to work. Whereas on my machine, I wouldn't have been able to. And I'd like to share something, since you asked about the disability thing, about another thing that I am seeing, is that I am seeing a lot of people transition from a traditional steno school when they get stuck at the plateau levels that everybody has get to 180, and we see a lot of people are frustrated and are not making progression. I have seen many, and I don't have a number because it's all anecdotal from the people that I meet. A lot of former steno students have crossed over into voice, and they bring that background from their steno schooling into the practice of voice writing. So they have that background of understanding the record and making the record, and really some of the terminology and things that we're also taught in steno school.
And just my final question, I promise. So, Mr. Scott, you said, and you could probably look at your screen, I think you said this twice, you're looking for a change. The first time you said it was a change in legislation. The second time you said it was a change in litigation. So I just wanted to clarify. She's nodding her head. So
Then I misspoke.
Right. So I just wanted to clarify. I think you're asking for a change in legislation to be okay.
There are some
Just
changes
wanted
in
to
litigation I'd like to ask for
clarify.
also.
We don't have that power.
Okay, I was a little scared for a second. No, thank you. I appreciate you being here.
And originally, Board Member Nutella, there wasn't an ask at all, so he just verbally put that ask out for the board.
Got it.
Should be clear. Board Member O'Neill?
I was familiar with this.
Okay. I have a couple questions. How many members does the association have?
Association has currently about 750. Now that, of course, doesn't account for all the voice writers out there that are not members. I can tell you there are many people here in California that report in workers' comp cases. This is what I hear from them, that they can't work in the state court, but they can work in workers' comp. They also card and caption here from California, and these are all people that are looking, if they have the opportunity, to work here in California.
And that's probably pushing it. Well, I'll just ask it. How many states are voice writers able to practice in?
Currently, 38 states, the District of Columbia, all armed forces installations, and all federal courts.
Okay. And what are the challenges that you find in voice writing?
short of people's perception and changing of culture?
Well, that's exactly what I was going to say.
Was that it?
Our issues are the same as in machine writers. People talking over each other, people just going crazy and speaking 300 words a minute, unfamiliar vocabulary, the same issues. The same issues you all have.
Okay.
And let me go back to the people who are currently working. This is a worldwide profession. We have people in Europe and Asia and the islands and all over the world that are using the stenomask or the voice writing system. It's not just confined to America.
What is the training time?
Well, just about everyone can speak. I guess the short answer is it's like machine writing. It depends on the individual. I know our schools, some of our schools advertise 4 months, some advertise 6 months. We can take, it used to be before the advent of computers and we were simply dealing with a tape recorder or a digital recorder and a mask, we could take a college graduate, a second career individual, and we could turn them out in a month or two because all we're actually teaching them is transcription. They know how to speak. We can teach them in no time at all how to identify your speakers, how to dictate in the courtroom. After that, it's speed and transcription. We don't have that opportunity anymore with the advent of computers and software. I mean, it takes a little longer. But I know some of our schools advertise 4 to 6 months. Year at the most, tops, but we turn them out pretty quickly. Naval Justice School is only a 3 or 4 month program. They turn out all the voice writers from the military.
And can you comment to the dropout rates?
I'm sorry?
Can you comment on the dropout rates?
Well, from schools, virtually none. We don't have dropouts. If you want to be a reporter, I mean, we don't take just anybody. I mean, you want to be a reporter, we'll make a reporter out of you. It's only a couple of months of your time. It's not that big of an expense, aside from equipment. But our schools boast 0 to 1 or 2 per class, if that. Nobody, we just don't drop them out.
Okay. Any additional questions?
Where's, I'm not familiar with the schools so are there any schools in California that you teach?
Not that I personally know of. Of course, brick and mortar schools are just about non-existent. What we find is there may be machine writing schools that have a side curriculum of voice. I find the dropout there to be greater simply because the teaching is not as good as, say, in a voice writing school because they simply advertise for somebody that knows Dragon, knows speech recognition. They try and teach them how to use it on Eclipse. So the teaching itself lacks. I find dropout worse there. I don't know of any brick and mortar schools per se that are isolated to voice. There are CCAC is what I'm thinking. Do I have that right? CCAC. Anyway, there are schools out there, brick and mortar schools. I just don't get involved with them. Couldn't tell you on that.
Okay, thank you.
Tri-C.
Are there any public comments on this item? And I see a few hands up. Do you mind maybe giving up one of the mics so that we can have public comment come forward?
Of course.
Okay, please. You are welcome to state your name, but you're not required to do so.
Okay, my name's Joanne Sitsui. I'm the Chief Hearing Reporter for the Division of Workers' Compensation of California.
Okay, thank you.
I just wanted to clarify, Mr. Scott made a statement that he believed that possibly we were employing voice reporters, but we do not. They're required to be stenographic reporters currently.
Are there any other public comments? Okay. So as I had initially said, there was not an ask when this packet was put together, but we have now got a verbal request from Mr. Scott as it relates to putting forth legislation to allow licensure. And it's my opinion that we don't have to answer that question right now. He's given a lot of information today in this meeting, and also we've received that through email. We can marinate on and decide what's the best path forward for California. As everyone knows, when it comes to a legislative change, that requires many different entities involved in that process and much time. Our sunset review is coming up, and maybe that's an area to talk about. Are there any thoughts on creating a task force or just learning about this more and coming back around to this in September? I'd like to hear the board's question.
If I can jump in as staff, I don't really think that it would be necessary for a task force. If you want industry input, then you would probably want to convene a couple of town halls, one north, one south, and see if you can get industry input that way. We have time to do that before the September meeting.
I'd love to hear more information
Me too.
about this opportunity
From the industry?
From the industry. And when you say industry, who does that include?
Well, they would be public meetings. So we traditionally invite all stakeholders. So obviously that would be the trade associations. We typically try to get it out to court systems, to the bar, any place that we think that that potentially would be interested in that particular topic, whatever that topic is. In this case, it's really broad, so we would be inviting all of those people.
So a town hall is time intensive, and I want to remind folks that we do have a sunset review that has to be done by December. I do want to hear from the industry. I'd like to hear from all the stakeholders, but I want us to be clear about timeline and schedule. And having the staff do that between now and the next meeting, I think, is asking quite a bit.
Can I add something? Not only do we have sunset review, we have strategic planning coming up in September. And if we're proceeding with this, then I think we have to at least have a placeholder in our strategic plan for this.
The town halls would have to be accomplished before the board meeting in September in order for the board to vote on how they want to move forward. I'm hearing the board asking for more information.
Yes.
From a broader audience.
Yes.
That's why I'm proposing or throwing out the idea of the town halls. The timing obviously is up to the board on how quickly you want us to respond.
Is it possible to ask for those other stakeholders, the other parts of the industry, to send us comments? I mean, do we have to hold a town hall?
We don't have to. We've just found that people, you get a better feel for what's actually out there when people can respond to a comment. If it's in writing, I don't know what you sent in, if you sent anything in. I don't know what Ms. Nocella sent in, if she sent anything in. So I can't respond to anything that she might say. So if we put it into an oral setting, into a hearing setting, we've been very successful with people stating their point of view, having rebuttal, just to it gives you a fuller picture, I think, of what the prevailing feelings are.
We did this with the STIP, the SoCal STIP.
We've done it a number of times.
I have a thought. With the September strategic planning and board meeting, knowing that we're going to do that and work on sunset review, when is the next time we're going to be meeting? What do you think? February, March?
That's what I would guess. It would be late winter, early spring.
My point is, because I think the ask or consideration is to explore an opportunity for legislation or, get more input from the industry, we're at the very end of a 2-year session. And there's nothing really legislatively that's going to be done from September to December. So if we, and cognizant of the staffing time that's needed, if we do strat planning, do our sunset review, and then next year take this on, because it's the beginning of a 2-year session, the beginning of the year, and we can talk about if that's something we want to go and explore after. Just, I'm trying to be mindful of the time frame as well as staff needs.
I'm inclined to do it sooner than that, only because if you're introducing legislation, usually isn't the deadline for that like February?
January.
It's pretty early.
Proposals have to be submitted in
So,
January.
It would
yeah.
have to happen in September.
It depends on how urgent the board feels that the issue is.
Well, being responsive to the labor supply and trying to find low-hanging fruit to like take care of that is important to me, and I think from the board as well. And this may be one of those lines of fixing or assisting in the labor supply shortage. I think, as I said before, because it's a legislative walk, the sunset review can be a pathway to understanding this issue. And prior to that time, people can send us comments about what they think, and they can also send comments on sunset review about this topic. So we will get to hear more of the industry. And so my feeling is, and this is my own, that we should continue to gather information. People should continue to send us send us comments about this issue, and then we look at it again in sunset review and strategic.
Do you think we will get a robust enough comment section though? And I think that's what we're looking for. We're looking for a very robust comment period with a broad section of constituents. And I don't think we're going to get it that way.
I hear your questioning of whether we're going to get the voices that we want to really get a broad understanding. I also know that at some of the town halls, we didn't get as many folks as we thought we were going to get out to them.
I get
and
that.
It is a cost to the board on a very tightly budget that we have. So it is an additional meeting, one would say. So I do understand where you're coming from. Do others feel similar to Board Member Lazinski about the town hall being more efficient and a way to get more voices to comment on this?
Are you going to make the code? Go for it.
No, it seems in the past, I'm trying to think of another word besides crapshoot.
You used it, so now you can continue.
As far as the response to town hall meetings, as far as people showing up. So it isn't a guaranteed way of generating higher interest or higher response.
We have another public comment. Would that help maybe with formulating? If you could come forward. You're welcome to state your name, but you're not required.
Anna Costa, and I am a former court reporter, RPR, CSR, retired, and I'm a coach and a trainer of court reporting students. I think we're using a webcast. We've got Tori doing real time. Why not do the middle road? And I think it's, you made a compelling presentation, both of you. And it is very scary what's going on out there. Students are not able to pass the CSR. I have a lot of information why I believe that's happening, because I've worked with dozens of them over the last 10 years and read hundreds of transcripts. So why not do a webcast, Zoom call, get it out there and invite everybody to participate. Then you have their faces and they're live, and you're getting the instant feedback. And they can also do a chat. So if price is a consideration, I can understand where you have a concern about that. Then you can open it to all of California. You don't have to separate it north and south. Everybody's invited.
Thank you for that comment. Is it possible to do the town hall with the strategic plan meeting?
You wouldn't have the information in time to use it though. I mean, you would want to have the comments and the information before as background, before you try to make decisions with it. At least that's what you've wanted in the past. So I think that Ms. Costa gives us an alternative that's very usable. Even if we did it old school and did it north and south, there aren't rental costs associated with that. We find state buildings, so we're not charged rental. We have staff trying to staff it right now. I think it wouldn't be expensive to do before the meeting.
Before the September
Before the
meeting.
September meeting.
And do board members need to be present?
They would be invited, but we couldn't have a quorum, so we would
Right.
have to discuss amongst ourselves.
We could have a quorum if.
They don't talk.
No, if we notice it, if we're gonna know more
We
than 10 days in advance, so we could notice it.
Yeah.
Okay.
There was a question there.
Sure, do we have another public comment or question? No?
She had her hand up.
Okay. If you change your mind, just let me know. Okay. All right, so we've got a lot before us. Do we think that a town hall is appropriate? It sounds from the staff point of view they can make it happen before September.
Yes.
So this would be an opportunity to hear many stakeholders in the industry, and it also gives you all more time to gather information and talk to peers in other states, what's happening, and come back to us and give us more in-depth knowledge about what it is that you do.
We can work with the Department of Consumer Affairs to find out what the technological capabilities are with the WebEx and things like that. So
Okay.
it might not have to be a physical nor a physical south. So I'm guessing that part doesn't matter to the board.
I think for me at least, the more that can participate, the better. And if we can facilitate all of California speaking through technology such as video cast, let's do it.
Okay.
So, would someone like to make a motion or to the effect of having a town hall prior to our strategic plan?
I have a question. Are we talking about one town hall or two?
Well, as was just stated a moment ago, there may be a way where we only need one town hall and is open for all of California.
Okay, because I couldn't hear everything that was said down there. Sorry.
That's okay, no.
So you're talking about webcast type of thing.
Whatever they can do
Whatever
to
it is,
facilitate all of
Okay.
California to be a part of a town hall prior to September.
If that technology is not available, then we would do physical north, physical south.
Okay, so the motion would be to have staff prepare for and notice a town hall that would encompass the entire state to discuss verbatim reporting.
To discuss the current state of voice
Sorry.
writing and to discuss the current state of voice writing and see what legislative options there are in allowing licensure.
So you're thinking that the town hall is gonna come up with legislative options?
No.
Oh.
So it's your motion, so I'm
Yeah,
not
that's
telling you
why
what
you
to
just
think.
went somewhere where I wasn't thinking we were going.
Well, you know what, it's your motion, so I'll let you state it, what you would like to say.
So this is what I thought we were discussing, but maybe maybe I'm not right, that we would like staff to develop to plan and notice a town hall meeting that would encompass all of California being able to at least participate via technology, to discuss verbatim reporting,
Specifically voice writing, because.
specifically voice writing. Okay,
Because currently it is verbatim, it's all verbatim.
okay.
So if I could just trim that, you're just directing staff, I'm hearing you're directing staff to convene town hall meetings to discuss.
Is that not how that would normally be?
Yes.
Okay.
So we have a motion on the floor. Is there a second?
A second.
Okay. Any public comments on this topic? Yes, please.
My name is Rachel Barcume. I'm from CCRA. I just was wondering if there would be voice writers present at those town hall meetings that we could ask questions to, or if it would just be a discussion among reporters in California and stakeholders here.
So we can't command somebody to attend, but they would certainly, as stakeholders, be invited.
Okay.
May I make a comment to that? So in knowing that Mr. Scott and Ms. Pittman took time and effort, money, and travel expenses to come here, it's clear that the expansion of this profession in California is important to your association. And understanding that and knowing that, I think our staff is going to go through, it's not the trouble, but the effort to put forward a town hall to encourage this dialogue. I would say it's probably incumbent upon your association to have a fantastic turnout at this town hall to highlight and showcase your profession to the board and to the community. So I'll leave it at that.
Are there any other public comments? Okay. Any further discussion? All right, let's call to vote.
Ms. Crom is absent. Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Okay. Thank you very much for your presentation. We will take this at a future town hall and discuss it further. And I hope you will make yourself available for questions. We appreciate your time. Thank you. And also Ms. Pittman.
Thank you.
So as we continue in this agenda item 7 about the reporter labor supply, the board also received a special request from Veritex to permit currently licensed reporters excuse me, from other states as well as those who hold current RPR certification from the NCRA to work in California by passing only the written portions of the California license exam. This is an action before the board. Are there any Veritex representatives or anybody advocating for the request?
They were not able to be here, that's why it's a written request.
Gotcha. All right. So this is the request before the board. The staff recommends that we discuss the policy behind this. If the board is in favor of allowing reciprocity of reporters licensed in other states or holding the RPR and requiring only the written test be passed, there's regulatory changes that need to be made. In this case, staff recommends the formation of a task force, but let's talk about this topic and this request. Are there any initial comments that the board would like to make? Are there any questions that come to mind with the request? No questions, no comments, no discussion?
I would like to hear more, like public comment or
Okay, we can move it to public comment. Are there any?
Just because I don't. Or
Well,
I
let's
spoke out
move
of
to
turn.
public
I'm
comment.
sorry. I
That's
spoke
okay.
out of turn.
No, that's fine. I was trying to formulate my thoughts.
I don't have them.
We do have a public comment. Maybe this will help
Okay,
the
thank you.
formulation
Yes.
of our thoughts on the topic. Welcome.
Good afternoon. Thank you. My name is Kiran Guevara. I'm a freelance reporter in San Diego, and I'm also a CSR coach. My comment is in the form of a question. Don't we already have our PR reporters from out of state that come and take the CSR and yet do not pass it? And I would just leave it there.
Okay.
Thank you.
So just to clarify, the request is if you have the RPR, for instance, or any other state license, that you not come and take the test, that you just take the written test.
And I apologize. The intent of my question was simply to show that there are already RPRs that come and try to qualify or try to take our CSR exam and cannot pass the test, which begs the question, do they actually qualify? Do they meet the levels of standards to become a California CSR? And the answer, unfortunately, is some of them do and some of them don't.
Thank you.
Okay, that helped. That helped. That's what I couldn't put my finger on the words. And that is my concern. I've looked the way that we have it set up now with you either qualify in school, and those are not easy tests, or you have your RPR, and then you can qualify, take the state skills test. I don't think that should change. I don't think having an RPR should allow somebody not to take the state test. I think it's a good qualifying test, but not to be the only skill test.
I agree with what you're saying, Ms. O'Neill. I think we have to understand that our charge is to protect the consumers. And I worry about the consumers when you permit this type of action. And I'll leave it at that.
I think there's some public comment video.
Yes, absolutely. Come forward, please.
Hi there, how are you? My name is Cheryl Hobb. I'm the president of the California Deposition Reporters Association. I just have a couple questions, I suppose, ones that you probably are unable to answer now. It would probably be more questions for Veritext and exactly what it is that they're seeking. The first thing that you did mention was reciprocity for reporters that are licensed in other states. And I think that all of us, the first thing that comes to mind is the fact that California has one of the most difficult licensure tests in the entire country, if not the world. And I think that we would have to take a really, really close look at how people are being certified in other states. As far as I know, there are many states that use the RPR model, which, while is quite difficult to pass, is not really reminiscent of a lot of what we do here in California. Depositions, for voice, the 180 portion of the RPR certification is a literary test, which is something that we normally don't do as licensed individuals working in the legal field. So I think that we would really have to take a very, very close and hard look at how these people are being certified in states. And frankly, as far as I know, that Texas has a very difficult certification test, but California is second to none. So I can't imagine any universe in which reciprocity would be appropriate. There's also the question of something that I don't think occurs very often here. It did with me actually, but I did pass my RPR before I was a CSR. But if we were granting reciprocity with the exception of the written tests to RPRs out of state, I'm also curious as to whether that would apply to residents of California who pass the RPR but are unable to pass the CSR. Because as Karen mentioned, that is a curious thing that you're passing a certification test on one level but unable to pass another. Of course, this is a performance type career where, one day you can write very well and the next day not so well. But I guess the question is, would that only extend to out-of-state reporters seeking certification in California, or would that also apply to residents of California who do hold national certifications?
Thank you. Are there any other public comments? Please.
It's me again, I'm back. Jennifer Esquivel with CCRA, I'm the Secretary Treasurer. I'm also a freelance deposition reporter, and I just had a couple thoughts while we were discussing this topic. One is I would be curious to know how many requests there have been for reporters from other states to actually move to California and take advantage of this. I know living in California is quite expensive, and I'm sure that there are people who are reporting that would like to take advantage of this opportunity, but excuse me, but I would be curious to know how many, if Veritext has received requests from multiple reporters, from which states, if it's really something that is imminent and would happen sooner rather than later. I know we're all facing the issue of a possible labor shortage with reporting, and I'm sensing that this is Veritext's request to help with that. The other thing I would ask or inquire about is if this were to come to fruition, how would that play into licensure in California if you would be held to the same standards? Right now we don't have continuing education, but for example, some people who work in other states do have continuing education requirements, so would they solely be held to simply the CSR standards for maintaining their licensure? Would the application process be the same? Those kinds of questions, because if they're coming from other states, they may be working under different circumstances than what the CRB has here.
And I would just respond to the first part of that one, only because I've had a chance to speak with the Veritext representative.
Sure.
I'm not speaking on behalf of the company at all, but it's my understanding from our conversation that what brings the request forward is difficulty covering the calendar. And so
Okay.
they're looking for a wider labor market.
Right. So just
not that the out-of-state people have come to him.
I see. Okay. So maybe just inquiring about relocation to bring more reporters here to cover the work.
Outside of state to bring it.
I see. I understand.
Yeah. And I have a comment to make too. This particular period of time has probably been the worst as far as the labor supply, but we've had these situations before, and every time we have these situations, the talk comes about lowering the standards. And I think that is a bad road to go down. That's one thing. California's known for a lot of things, but one of the things is that they're rigorous testing. When I went to work in another state, they were all impressed by the fact that I had passed the California CSR, which surprised me. For one thing, I was thinking, how do you guys know? But I can see having a discussion about voice writers, and if there's a fit, we can do that. But I still am at the point where I don't want to lower our standards in order to get more people. I don't think that serves the consumers of California at all.
Well, and that's actually relevant to my last comment, which is I think that there is a difference between a 4-voice test and a 2-voice test. I think the circumstances can vary greatly when you're responsible for taking down 4 speakers. Obviously, it's something that's attainable because many of us have a license, but it is a different standard for the test, and I'm sure that California deemed a good reason for that difference. So that's everything.
Do we have any facts on what other states have a 4-voice test?
My understanding, Nevada and Georgia.
similar.
Hi, Carolyn Dasher. I'm just here to ask a question as a court reporter. So I have to put on a different hat. I'm a court reporter here in Los Angeles. So it's just a question. Must a licensed California CSR be a resident of California?
Not currently.
Okay.
We have licensed CSRs all around the world.
It's a constitutional issue. A federal constitutional issue that's been decided with regard to professional licensing. The threshold for demonstrating that residency is necessary for licensure is so high that it's almost never going to be one of the requirements. They may have an obligation, although this board doesn't currently, it may be possible to set an obligation that they demonstrate their intent to practice here, but residency is not required.
Okay, thanks.
Are there any other public comments? Yes, please.
Anna Costa again. I just wanted to agree with Ms. O'Neill that we need to keep our standards. And the bar in California is one of the two most difficult. New York is the other. Strangely enough, there is no CSR in New York. You can work without having a CSR, or even an RPR is my understanding. So very different for voice and to voice, although I highly recommend to my students to write a minimum of 225 words before they go get CSR so they have a cushion. But I'm really happy to hear that you are not going below 200 words a minute. The standard's been in place for a very long time, and we just need to change the way the students are learning. Maybe they need a different learning style. Thank you.
Thank you. Any other comments from the public? Any other comments from the board? I think I will definitely echo Board Member O'Neill's comments that our standards are important and they're for the protection of consumers. I don't believe that Veritex and their requests have demonstrated a state of emergency on supply. I'm looking forward to that evidence, but I don't see it yet. That would warrant us looking for reciprocity outside of California. I do believe it is a complex topic, as has been demonstrated by the questions that have been asked. Because if you allow other reporters to come in, what does that say to the existing people who are trying to get across the threshold, and who's accountable for what aspects of the law? So with that said, I tend to see nods and shakes that the request is going to be denied. And of course, as a board, we will always keep ourselves open to learning more and gathering more evidence as to whether it's necessary and needed. But at this point, we do not see it valuable to permit currently licensed court reporters from other states. Reciprocity. Yes? We don't need a motion for our, yeah.
You're not directing staff and you're not taking action, you do not need a motion.
Absolutely. Okay, great. And the staff does recommend that the board work with the Office of Public Affairs to expand the communication plan, and maybe we'll talk about that a little bit more on how to communicate to the public the importance of hiring a licensed court reporter. Is anybody opposed to the staff recommendation? No? No. Okay. So we accept the recommendation and support it. Is there a motion in that acceptance of recommendation necessary?
So moved. You're asking staff to work with the OPA?
Yes.
Yeah, I would.
Just to
So that you
make it
have
official and
concurrence.
formal. So I hear a motion from Board Member Nocella, and is there a second? Public comments on that? Okay. discussion? Call to vote.
Ms. Crom is absent. Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurd?
Yes.
Motion carries.
All right, I think that's everything of agenda item 7. It is the reporter labor supply and the question of whether there's a shortage. Are there any further public comments, anything that folks would like to say on this topic? All right, hearing none, we will move on to agenda item 8, qualifications of candidates for skills exam. The staff recommends referral of unsuccessful candidates to the trade associations for mentorship opportunities. Do the board members have any comments they'd like to make on this agenda item? Okay. Are there any public comments on this topic? Please, if you could come forward.
Karen Guevara, freelance court reporter in San Diego and also a CSR coach who's worked with students working hard to pass this test. I thank you for putting this item on the agenda because it's a subject very near and dear to my heart, and I wish every single CSR candidate had the same experience that I did in presenting to the test, fully prepared and confident enough to pass this test the first time. Because as is noted in the agenda and in our experience, the first time is the best time to pass it, and your chances go down from there, and you're a little bit emotionally damaged from it, if not a lot emotionally damaged from it. And it's a shame because court reporting is such a marvelous profession with so many wonderful people, but it takes brain, skills, talents, and most of all, guts and determination to get through this. And so the process for licensing takes the same, and we all appreciate that. We want to keep our standards high. My intent in bringing the subject to the fore is to add to the awareness that the current system for qualifying and preparing students for the CSR is not working to their benefit. I'm concerned that they're just not ready when they come here. And I've had the privilege to personally observe the process both as in helping write the skills exam and helping write the written exam and observe as a proctor. And I see that it's a fair process and an entry-level one. There have been volunteers with me that have invested weekends and hours on end counting every single word and every single syllable that goes into this exam. And it's because we love our profession and we love all of these hardworking people that are trying to enter it. We want them to succeed. And I've also had the privilege of interviewing CSR candidates and new members of our profession to get their input as to what they think is a problem. And on the one hand, I have heard from candidates that have expressed to me that they knew coming to this exam that they weren't ready to pass it, that they weren't expecting to pass it. But since it's only $25 to retake, what the heck, I'll come and hang out with my friends. They've told me that teachers from their schools have told them that they were being put out as lambs to the slaughter because their school was closing and they wanted to get people out of the program. And that may have been the reason why it was requested that we only have one qualifier instead of the traditional 2 and 3 that we had in years past. Successful test takers have told me in detail the investment and work they have put into making sure that they didn't have to take this test over and over again. And that's shot them to the front of the line, ensuring that they can make an income beyond their wild expectations and effectively making the cost of not passing this test a really costly one. I know of one reporter who shared with me that she's only been a reporter 1 year, but she's making money that she couldn't believe that she could ever do not being a court reporter. So I've seen, as was it the Joni Mitchell song, Both Sides of the Cloud, and I've seen clouds from both sides now. And I would ask and maybe suggest that one of the considerations in helping people pass is to reconsider the minimal cost, because I noticed that the attitude is it's a minimal amount of money to retake, so I don't have to try because I can try again. I heard one candidate tell me in the elevator at the last test, well, I don't think I passed it, but it's only my second or third try, so I'll just come again. There's a laissez-faire, I don't know how to pronounce that word, never have been able to, as to just coming in and taking the test over and over again because, oh well, we're not expected to pass it the first time. And it doesn't cost me very much to do so again. I also think that maybe instituting a requalification for candidates who have not passed it after 3 attempts, maybe they need to go back to the writing board and see if they can requalify again, and or reinstituting a 3 qualifier requirement before becoming a candidate to the CSR, just to make sure that you're really actually prepared to take this test and to take it with the seriousness and dignity that it deserves to be taken with. Thank you.
Thank you.
Hi, Carolyn Dasher, CCRA. So, we do have a mentoring program. We're really happy to take any mentee that wants to come. In fact, when we're here, we're talking to students and talking to test takers. And Los Angeles County Court Reporters Association also has a mentor program. So we're here, we're ready, we're happy to take them, give them to us.
How many folks are in your mentorship program? Do you know?
I don't know, well, I'm not sure. We have a list, like we have people on our Support Our Schools committee, and then the mentoring committee is below them, and then we have court reporters all around the state that are able to mentor, but we can always get more.
Okay. I know I was at one exam where I saw you all had a table set up and you were talking to students. Would that be the opportunity? I mean, they
Sure.
don't know then, right?
Sure. Yeah, and they can go on to our website, and that's where they would reach out with an email. We also do scholarships, and they are able to get money for their schooling, and then we also sponsor students for our convention where there's a way for them to learn more about court reporting and then they can meet reporters, and then they actually see reporters, and maybe they'll find a mentor there. I know the schools, I've gotten my mentees usually through the schools contacting reporters, and then they just come sit out. I mean, I can have 3 or 4 at one time.
Thank you very much. Are there any comments from board members on this topic? I just want to be clear, the test hasn't changed dramatically at all. I mean, this is a test that's been given for quite some time.
True. I can address a little bit the cost issue that Kevin brought up. So right now it is $25 per section of the test. As part of the fee regulation increase, we're increasing that to $50, and it's capped by legislation at $75.
Also, in order to increase, decrease, or set that fee, the board has to justify that by demonstrating how much it costs the board to give the exam. They may not use the fee for a deterrent purpose.
Thank you. And I have to say, as a person who took the bar exam, I understand the toll that it takes on one's mental, maybe trust and confidence in oneself to accomplish this. And it means a lot to stand up and to take this exam, but each time it needs to be taken very seriously. And you have to go into it thinking that's your last time. And I really urge those who are in the mentorship program to help those that while they may not see it as a toll on their mental confidence, it will be after a period of time. So
I heard 2 asks from the speaker. One is to reinstitute the 3 qualifier requirement, and one is to require requalification after the 3rd unsuccessful attempt. Does the board want to address that now? there are schools here. That's why I'm saying if you want to hear from schools, since this meeting is in conjunction with the exam, it might be our chance to get some input from the schools.
I think that, could I speak statutorily to the second of those?
You sure can, go ahead.
There's a general business and professions code section. I'm sorry, I can't reference the exact code because of the lack of connectivity in this room. There is a specific business and professions code section that says that absent the legislature giving you a statutory authority, the board may not implement any barrier because somebody fails an exam and require them to go through additional steps. So that would require specific legislation to overcome that prohibition, that statutory prohibition.
Okay, well, that's the foundation of a discussion. Okay. Where it begins and ends. It still might be favorable to hear from the schools about candidates qualifying for skills exams and how we're seeing that it's becoming difficult, the numbers are decreasing. Are there any schools that would like to speak to qualifications? We won't put you out if you, if you don't want to come forward. That's fine. Okay. Are there any further discussions?
No.
Okay. Well, there was a staff recommendation to refer, actually, here's a question. How many unsuccessful candidates call the board and say help?
0.
Okay.
The board doesn't help them, that's why. I mean, that is not our role. Our role is to develop and administer the exam. We're not here to produce a study guide or give them hints, so to speak, or coach them or mentor them. That's not our role.
Okay. And nobody's reached out for that, even though?
Well, they will reach out for study guides, for information on where to get information to study for the written. But we haven't had anyone that I know of reach out to ask for help to practice to get faster or more accurate.
Okay. So it's been stated there, sure, come forward, please. It's been stated that there are mentorship opportunities, and the board would just like to reiterate that those who are unsuccessful candidates, that they really seek them out and get stronger.
Hi, my name is Yolanda Krieger. I'm the court reporting director at South Coast College. And I just wanted to go back to qualifying and the pass rate. So last July, I believe we had 11 or 12 pass the CSR, and we've maybe had 3 since then. So I don't know what happens, because we really do prepare our students. We've had people that are going to the test pass multiple tests. It's not like multiple qualifiers, so they're prepared. I don't know what happens when they get in there.
I do, it's nerves.
Well, that too, but these are people who pass multiple qualifiers, not just one test or barely pass it. And to have 11, 12 people pass one test and barely have 3 or 2 for the next couple tests, I don't understand. We don't know what's going on.
So does your school have a plan, or have you had any strategic meetings thinking about how are we going to address this? Obviously, the higher numbers you produce, the better it looks for your school.
Exactly.
More will come to you. So
Right.
what's in place?
We tell our students, just make sure you're at school, make sure you're in qualifiers, evaluate your tests, work hard. I don't know what else we can do. Some of them go and sit out with reporters. They do, they get a mentor, and we don't know. We're kind of at a loss. And we've always had decent pass rates, so.
And we've actually had teachers who come an hour early in the morning and stay an hour after, just working with these people. And,
Right.
devoting their time, not even getting paid.
Extra time.
To do so. So it's very frustrating.
And are there any programs, kind of like there are for the bar, to prepare for this?
Well, we're qualifiers. Qualifiers. I mean, we do it.
Every single qualifier with the students.
So our qualifier, they do the qualifier in the morning, they transcribe, and then they have to grade. So I sit there, I read it to them, they grade their test, they see. So we do that every week. Plus if they're there 4 days a week, 5 hours a day, plus extra practice. And, and people are passing qualifiers. It's not like they're not passing them. So our repeaters are passing.
You can come forward.
And I'm not saying every single repeater's been at school, but they're, the majority have been, so.
Thank you.
Yeah, thank you.
So it seems you have a couple of other public comments, yes?
Yes. Should I go first?
No, go ahead.
Okay.
Is it a tag team?
I'm not sure what credit I was going to say, but I'm sure it's entertaining. So there is another option, and it's very effective. How I train core reporting students and new reporters is that I have created this program over the last 10 years where I am in collaboration with law firms, law schools, and litigators, where they have mock trials and mock depositions, and I bring the court reporters. So the students, and I've lowered the standard a little bit. I was initially asking only for students that are writing at 180 because they get credit at 180 words per minute. They need to have internship hours or apprenticeship is what you call it, I believe. And 10 of that can be where they are at mocks. Although I believe that my program, where they are the reporter of record, they are not shadowing me. They are not shadowing another reporter. They are in a room like this with about as many people in the room as you. And they are reporting what is being said in a Q&A format for anywhere between 12 minutes at a time to an hour and a half. And then they produce transcripts, rough drafts, which they don't learn to do in school, or final transcripts. And I review every one of them. I ask them to submit, and I am there during the entire 3-hour session, and there are multiple sessions happening, so I need 3 reporters in 3 different conference rooms to be reporting this many people. So then I asked them to send me, within a couple of days, their most difficult Q&A session of a minimum of 12 minutes, and in its raw, unedited state, and the same file in its completed rough or final format. And I provide all the materials they need, and we have coaching calls to prepare them, and I invite my graduates to participate in the calls to give them the feedback, what they need to know. When I compare, and this is why I'd love to work with the schools, when I compare the rough, unedited formatted file with the final or the completed rough or final transcript, it is incredibly disheartening that they are not writing cleanly enough to be able to read. So this is an issue. A lot, I would say 99% of my students are not right, they are reading through their slop. So they are not practicing or taking enough qualifiers or reading their notes or something where they are cleaning their notes up, or they're always going for speed. I hear that all the time. Go for speed, don't worry about accuracy, get it later. That makes no sense. If you can't read your notes at the lower speeds, how are you going to read them at the higher speeds? So my program is helping them to develop confidence in overcoming the nerves, as you were describing, Ms. O'Neill. And when they get in there, I mean, I had a student that was 160 last spring, and she was so enthusiastic and wanting to do it that I said, okay, you can join my team. I want you on my team. And she was really nervous going in there. And at the first break, she had the biggest grin on her face. She said, "Oh my God, I got it." And have I encouraged her to come back and intern with me again? Oh, yes. She's coming back. And I'm inviting other students now at 160 to do it. They don't care if they get any credit. They're getting real life experience, real people. Asking questions with, various voices and speaking ability, as you're hearing me with my, dysphonia. So we can do this if we work together. Students have flown from the East Coast to participate in my internships. They've driven up from LA. They are committed. They heard about it. They want to succeed, and I am there to help them. And most of my time is volunteer.
And I appreciate Anna and I have each developed programs on our own, and I think probably the foundation of the program is confidence. Confidence in being able to get over those mental barriers that they're walking into this test. Yes, they can practice and practice and practice all they want, but if they've got these blocks of, oh, but the reader, oh, but the speed, oh, but the chair, oh, but the speaker, there are mental and emotional things that cannot be tackled in school. It needs additional help and attention, and maybe these students who are retaking need some extra care, time, coaching, mentoring by people who have the skills to be able to do that, developing programs in that field to help support them so that they know this is doable. I did it. I started school when I was 17 years old. It took me 8 years because I was doing it part-time, and I was 17 years old. My brain wasn't gelled right yet. But I came and I took that test, and gosh darn it, I passed it the first time because my teachers accepted nothing but the best. And they accepted nothing but my being totally and absolutely prepared before they let me into those doors.
Thank you. Are there any other public comments? Please come forward. I think from the board's perspective, we want everyone to be successful in this test. It's what the consumers need. And we definitely appreciate all the thoughts and comments on this.
Hi, I'm Chase Campbell, also known as Brandy. I'm from Dublin, California. I attended the former school, Golden State College of Court Reporting. And first and foremost, I would like to say I thank all court reporting schools for their service that they provide, and also for the board. Court reporting schools saved my life. I couldn't ask for more. There are skills that I have acquired that I didn't know that I obtained. And I'm able to, in the future, use those skills for my profession, and also primarily to the consumer. I can now, these skills that I have acquired, I can now perform. And I'm really thankful for that. And for all the schools, thank you for your service. And I really do want to say that since the school shut down, the first thing I did is I went to the Echo J, and that's East County Hall of Justice of Dublin. And I go there ever since the last test. I go there every day, 8 to 5, and I sit in the calendar department. I sit in that department, which is my favorite department because it's the most action and it's the fastest of all. I've sat in family law, I've sat in your civil departments, but I love sitting in that calendar department where there's arraignments and your attorneys and pleas and whatnot. And I have to say that took the determination that I have. And that's what this takes. We're going to have ups and downs, but for the student, I think it takes a lot of zeal and it takes pride in what you're doing. And if you want this, you have to get it. Meaning you have to, if you need help, you must acknowledge that you have some faults and that there are some things that they must change so that they can get the help that they need. And that's really just all that I want to say. And I'm just really happy to be here as well.
Thank you. Thank you for your comments. Any other thoughts from the board?
Well, these are all very insightful and helpful, but I don't know that there actions that the board can take?
There aren't. I mean, as the staff recommended, we can just send people to the mentorship programs and associations. But we wanted to, I guess, give a platform for folks to talk about this topic, because if everyone remembers, we redid another test to give people more opportunities. And again, the public is best served by having knowledgeable, able court reporters out there. We want them to be successful. So I think we can move on to, thank you all, we can move on to agenda item, where are we at now? 9. The online skills exam.
I promise to be quick and we won't come before you afterwards.
Oh, absolutely.
Oh, yeah. Oh, yeah.
So, this is strictly informational. I just got an updated proposal. This has been on the board's plate for a little while, so I went back to the vendor to make sure that the proposal that I had was current. There's a slight adjustment, nothing that's going to be significant or get in our way. So I will be moving forward with contracts as I move forward with regulations with Ms. Parker, so that we can get that going as soon as possible.
I hate to ask this question, but is there any kind of timeline, or I know? No. Okay.
Whenever there is a regulation involved, my answer will be I don't know.
Okay. Any questions? No? Okay. Well, thank you for the informational, and it sounds as if we need a comfort break of 5 minutes.
Okay.
That was different.
Needs a warm beverage.
Oh, no, that one I think you want me to sleep. On top of my already wanting to
Like that.
Reporters board meeting is back in session. We are resuming with our meeting with agenda item 10. This is the request for declaration regarding Byrd versus Barkley. Is there anyone from Byrd or Barkley that'd like to? I see a hand up. If you could please come forward. We have a brief summary of the request, but anything else you'd like to say to add?
Yes. My name is Mark Larry. I was one of the attorneys who represented Barkley in the underlying case. It appears from my reading of what was asked of this committee by Byrd's attorney is to declare that the ruling has some benefit to the consumer. I would suggest that the premise is wrong and factually it's wrong. We start with the premise. I guess the premise is that by reducing the amount that court reporters can charge per page at court hearings or trials, that somehow the consumer would benefit from that. I would suggest that, as we've heard today, with the shortage of court reporters, lowering the rates that court reporters can make is not going to solve the problem for the consumer of having enough court reporters out there. More importantly, though, the decision itself shows the fallacy of this argument, because what the decision now allows, or has always allowed, is that although it puts a limit on the per page fee that can be charged, what the courts have all unanimously said is, but this doesn't restrict the amount that can be charged as a per diem or other costs. So what has transpired is that in order for the private court reporters to make it worthwhile to provide this service, is they've increased their per diem costs. And I would say that, if anything, that's hurting the consumer at large, because now they're paying a higher upfront cost and they're not actually paying for what they're getting, which is the per page normal cost. So instead of, for example, if the court reporters were there for a full day hearing and they would charge a normal rate per page, that's how the consumer would pay. What happens now is if, for example, in the same example, a court reporter was there for a 10-minute hearing, they would have charged the same rate per page, and the consumer wouldn't have gotten the benefit of only paying for what they received. Instead, what is now happening as a result of this decision is that court reporter associations or businesses are charging a higher per diem regardless of whether it's a full day or a 10-minute hearing, because they have to make it up somehow. And so I think, it's early on, but I think what we're going to find is that, one, there is no benefit at all to the consumer, but if anything, it's going to be a negative response to the consumer.
Okay, thank you.
Thank you.
Welcome.
Hello. We did submit a letter on behalf of CCRA, so I'm not going to go over that, but I really would urge you to decline the request. For one, we know that the transcript rates are 27 years old, and we are not happy with the decision that came down on the case, and I would urge the board not to take a position on this, not to decline the request.
Thank you. Are there any other public comments? Okay. So this is now back before the board to discuss. Any comments or questions?
I am not comfortable with what they are asking for because that to me is opinion versus fact. And if it was fact, we wouldn't even be having this discussion because it is what it is. And so that's my position.
Okay. Board Member Lozinski?
I'm not sure that it's the board's job to do what is being requested. And also, we've already been through this process before. So I'm not in favor of moving ahead with such a declaration.
Okay.
Yeah, I join both of my fellow board members. I'm not generally supportive of a party asking the board to issue a declaration that I think could be used against somebody else in a legal proceeding or for political purposes. And I think it undermines the ability to further ask for additional increases in the fees going forward. So with that, I will yield to you, Ms. Hurt, but I am not inclined to support the declaration.
Okay. And again, I echo all the comments that have been said before. I think that there are other ways that they can try to put forth their opinion about what the board thinks. There's minutes. And we don't need to put a formal declaration in for them to prove their point or, as been stated, in a litigation to help support them. So, and they're not here to give any additional comments to sway that opinion. So it appears as if we will deny the request and move on to our next action. Does that sound about right? Mm-hmm. Yeah. All right. We don't need a motion for denial. All right. So that will take us then to agenda item 11, which is the website subcommittee report. Yay. The most exciting part.
Yeah, 3 o'clock. Rosalie Crab and myself, working with Paula to update the website. Trying to be kind. The old website was not the most user-friendly. So we are working on that and definitely trying to make it more user-friendly. And then I'm going to turn it over to Paula because she's really doing the behind-the-scenes work on getting this going.
One thing we've done recently is updated the bios for both the board members and the executive officer. We're combing through our current website to determine what information is obsolete, where we can streamline information, and how it can be more user-friendly, as Ms. O'Neill said. And we're simultaneously working with DCA's Publications Design and Editing Unit to develop images for the homepage in hopes that we can capture the profession and attract potential students. And once we have all of our information, our ducks in a row, so to speak, we're going to give specific instructions to the web team at Department of Consumer Affairs so they can build the new site for us. And we also, one of the features I was appreciating is that it will be user friendly on mobile. So it would, you know, change the way it looks when you're looking at it on a smaller device versus a laptop or a desktop computer. So we're hoping to have things up and running in the fall. All things considered with government.
Yeah.
But that's
It's a good goal.
Yeah.
in the
Any
fall.
questions?
No, but
Thank
thank
you.
you.
Yes,
That's great.
absolutely. We're very thankful and appreciative of that going through. And of course, the subcommittee's work on helping assisting, having another eye to the changes that are being made. So that takes us to agenda item 12, which is our strategic and communications plan. We have a long list of action items, some of which we've already kind of combed through. Would you like to make any comments?
It's just, we always bring it before the board for review, just to update you. The major changes from the last board meeting have really been revolved around cross-training. We've stepped that up. But again, if there are priorities to change, let us know. Otherwise, we are, as everyone knows, getting ready to roll into the next strategic plan. So typically, anything that doesn't get done on the current plan becomes the first topic of discussion as to whether it's still relevant. Do you need to roll it into the next plan?
Okay. So one thing that I would like to see happen is a convening of another best practice pointers. We did that a few years ago, 10 best practice pointers, and I think it might be important to do another 10.
I mean, updated or
To do
totally
another
new?
10.
New ones.
Oh,
And we still have the committee. I see a
When you're saying best practices, I'm seeing here with this expand compliance and education for licensees to prevent enforcement issues. Best practices are directly designed to look at what the requirements of the statutes are. I wasn't aware you guys had this, so I apologize.
Yeah, so because there are so many different things that happen in the practice, then we've had requests for instance, one of the best practice pointers has to do with how to handle interruptions. So there's nothing in statute on the best way for a court reporter to handle an interruption during a deposition, for instance. So the practice pointers are to basically be a springboard for discussion. So this is the way the board thinks it is the best way to handle a particular situation. It's not the grounds for any kind of discipline. It's not a regulation. It's not. It's just
advice.
It's advice.
Okay.
You would even say it's kind of an extension of the newsletter and the questions that come in there.
Yeah, it's not saying everybody has to do it this way because practice changes from north to south. Practice changes as the factors change. It's here's a set of circumstances. This is how we would advise you to handle it.
So we received a lot of great and positive responses when we did that before, and I think it's timely to do that again. Does the staff think that they can take that on or receive at least pointers from court reporters? They can send those ideas to the staff and we can convene another.
We have received a few, and so if anybody else has any more that they would want to send in, then that will give us a basis to start with to reconvene.
Okay. That would be my request when I think about the different action items on this list. A lot of things are in process, like we're looking at the website, and that's an area to educate stakeholders on the complaint process. We're cross-training, so I don't see anything that boldly stands out as needing to jump the line and be immediate, other than the best practice pointers. Since we already did it, I think we should do it again. And if I understand correctly too, we have the online skills exam process that's moving forward, and that's going to take a lot of your time up as well. Yes. Any other thoughts, comments? Okay. We are breezing through this meeting to agenda item 13, the election of officers. The election of board officers shall occur on an annual basis at the first regular meeting of the board after June the 1st. So this is time.
So I have a question. Would you be willing to serve another year?
It's good to get the nomination in first and early.
I know, right?
You blew that one to me. Sorry.
I did. Actually, I love this role, and I would be happy to take it on again. I'd like to see a lot of the different initiatives that we put forward, and I would be happy to do so.
Then I will nominate you for chair.
Okay. Are there any public comments? Any further discussion? Call to vote.
Ms. Crum is absent. Ms. Lisinski?
Yes.
Ms. Nochella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Thank you. Can I make a nomination for vice? Could I nominate board member Tony O'Neill?
Would you accept?
Yeah.
Second. Thank you. Is that a second? Public comments? Further discussion? Call to vote.
Ms. Crum is absent. Ms. Lisinski?
Yes.
Ms. Nochella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Done.
Thank you.
Okay.
All right. Newly minted again. I will move on.
You keep that.
I get to keep it now.
Really?
To use it. So moving forward, agenda item 14, future meeting dates. We have some activities coming.
So in working with Solid in getting ready for the strategic planning session on the 17th, they feel quite confident because of the prep work that they're doing that they can handle that in half a day, which would leave us half a day for a short board meeting. So hopefully we can wrap up a couple of these items, have board votes on things. So I would please ask you to continue to hold the entire day to make arrangements. As it gets closer, we'll ask you if you can come in the night before. If you're coming in the night before, that allows us to start a little bit earlier. But we'll work with you as it gets closer to that. But please keep the whole day, and that we will be able to do the board meeting and the strategic planning in the same day.
Excellent. Thank you. Any comments or questions? Are there any public comments? Okay. And now that brings us to agenda item 15, which are public comment for items not on the agenda. Public members are encouraged to provide their name and organization. The board cannot discuss any of the items that are not listed on the agenda, but you, of course, are welcome to talk about them. And we will consider that item for future board agendas. Are there any public comments? Please.
Right. Good afternoon.
Hello.
Chairwoman Hurt, former and current chair. Thank you for providing me this opportunity to provide a brief update. I know it's not on the agenda, but this is, I believe, my first time meeting most of you in my capacity as Assistant Deputy Director with Board and Bureau Services. Karen Nelson with DCA. I've been on the position for, 9 months now, and have had the pleasure, working with your EO and actually probably communicating with a few of the members here that's present. And as you may know, the Board and Bureau Services Office is there to be the liaison to your board and the executive office, and to help provide any support, whether in any of our divisions, whether it's HR, legal, whatnot. So feel free to give us a call if you need any support on that end. So just a couple of updates. I'll be very brief. I know we're trying to get through the agenda, and I'm the one pretty much holding it up. So the director's quarterly meeting will be happening Monday, August 6th. Please do mark your calendars, and I hope you all are able to join that meeting. But I also wanted to add, on June 25th, the director held a teleconference with board leadership, which included presidents, vice presidents, chairs, vice chairs of our boards and bureaus. And it was his intention to provide an update department-wide, and we spoke about pro rata, executive officer salary, an update on Assembly Bill 2138, and some regulatory process improvements. Thank you, Ms. Hurt, for attending and participating in that call. And with the initial success of that call and positive feedback we've received, we do hope to continue and have another one in the near future. So stay tuned when we do have that date available. Licensing and enforcement work groups. This year we launched licensing and enforcement work groups to really look at how to establish best practices across our boards and bureaus. And so we started that in April and launched with our executive officers, our bureau chiefs, as well as key licensing and enforcement staff within the department. And we began to meet monthly to discuss specific ideas to innovate in areas of licensing and enforcement. Specifically in June, we had a presentation from Executive Officer Joseph Morris with Board of Registered Nursing in talking about their Cloud Drive platform to really streamline their licensing processes. They also, the enforcement work group, heard most recently from the Department of Justice and spoke about the Attorney General's annual report, which contained baseline information on accusation referrals received and adjudicated accusations from our boards and bureaus. And I actually have a copy in my folder, and I'm happy to provide that to you and also provide the link to the board members. And the last thing I wanted to provide an update on is our board member training. As you may know, board members are required to complete a board member orientation training within 1 year of their appointment or reappointment to the board, and our next one is scheduled for September 18th. So if there's any one of you that's needing to take that, or if you want to take another refresher, we welcome you. And I believe that's a day after your strategic plan. So hopefully that would work for some of your schedules. And that concludes my brief update. And I look forward to seeing you all in Sacramento in September. And if there is any sort of need or support you'd like, feel free to give me a call or our office call.
Thank you, Ms. Nelson, for making that trip here and giving us that report back. Thank you. All right, that takes us to agenda item 16, which is a closed session that we had earlier. Are there any things to report out of that closed session? There's one item. I wrote it down.
The direction.
Yeah, but it got ripped up. I have it written down. It was So there is actually a report out on the closed session. And I had it on a sheet that got picked up. I got put in. I did. It was on the pink paper. Oh. It's got my horrible handwriting on it, so you might be able to see it. Top left corner.
Sorry, guys.
It's like the elevator music. You're on hold. Thank you very much. You are so speedy. Thank you. So the report out, the results for one of the topics, and I believe it is agenda description B. Thank you very much. With agenda description B of agenda item 6, the report out is the results were to broaden the authority of the subcommittee to engage in negotiations to resolve the matter in any appropriate means via the legislators and the governor. That will conclude that item, and believe it or not, this concludes our meeting, and there's adjournment.
Wow. Good job, Davina.